Thank you.
Thank you.
You may proceed.
May it please the court, Mike Patillo on behalf of HUB. This appeal follows from a trial under Section 4 of the Federal Arbitration Act. The trial concerned whether arbitration clauses in a series of brokerage service agreements between HUB or its predecessor, NAUF, and the Berkeley County School District required that the county's claims in this case be sent to arbitration. Much of that trial concerned whether 3 unsigned agreements from 2006, 2009, and 2011 were enforceable contracts. That's not at issue here. What is at issue? There were 2 signed agreements from 02 and 03, and the county did not dispute that those contracts were enforceable. Instead, the county said that they were irrelevant because it had amended its complaint to state that the alleged bribery scheme began in, quote, at least 2005 after those 2 agreements expired. The evidence at the trial, however, showed that the county's claims clearly relate to the services provided while those agreements were in effect. For example, the county seeks to recover millions for insurance policies it claims it didn't need. But the evidence showed that the county had been purchasing many of those policies going all the way back to 1996, and we believe discovery will show the county is still buying many of them. Critically, the county admitted at trial that its damages claim includes $2 million for policies approved by HUB or invoices sent to the county by HUB while the 03 agreement was still in effect. That is dispositive proof that the county's claims relate to the services provided in the 03 agreement and so must be arbitrated. The district court, however, refused to even consider HUB's arguments. The district court thought that this court decided in its prior appeal that the 02 and 03 agreements could not require arbitration of any of the county's claims and that the law of the case prevented it from reconsidering that issue. Respectfully, we believe that decision should be vacated for 2 reasons. First, we submit that the district court misread this court's prior decision. Second, even if this court had suggested that the 02 and 03 agreements didn't apply on the face of the pleadings, that did not bind the district court once the evidence at trial showed otherwise. Starting with the first issue, the district court's law of the case decision was based on its view that this court explicitly held that the 02 and 03 agreements cannot provide grounds to compel arbitration. Now, respectfully, we don't read this court's decision as explicitly holding that the 02 and 03 agreements cannot provide grounds to compel arbitration of any of the county's claims. To be sure, this court did state that the agreements predate the steering and kickback fraud scheme and conspiracy alleged in the operative complaint. However, we don't believe that is dispositive because the county's claims in this case simply are not limited to a steering and kickback scheme. The county has asserted claims, for example, for negligence, for negligent misrepresentation, and for breach of fiduciary duty that are based solely on recommending insurance policies that the county claims were outrageous, that it didn't need, and that no competent insurance broker ever would have recommended that the county take out. Now, those claims don't require proof of a kickback scheme. So if conduct relevant to those claims occurred while the 02 and 03 agreements were in effect, they must be arbitrated even if the kickback scheme started later, as this court noted was alleged in the complaint. So when this court explained that the arbitration clauses in the agreements could not require Berkeley schools to arbitrate any claims on the basis of conduct that began after those agreements terminated, the only conduct it mentioned in its opinion was the kickback scheme. The court did not address whether other conduct at the core of the county's claims for improperly recommending policies occurred while the 02 and 03 agreements were in place. The court left that issue for remand, and the district court's refusal to address that issue warrants reversal. Regardless of how one reads this court's prior opinion, however, there is yet another reason that the court's decision did not preclude the district court from considering whether the 02 and 03 agreements require arbitration. And that is because the law of the case simply does not apply when a court is presented with a different record at a new stage of the case.
Did you bring that up in the district court? Was one of your arguments not just how to read our opinion, but that the evidence had shown something different, and that was a reason for the district court to revisit the issue?
Yes, Judge Rushing. I mean, as you'll notice, the district court itself noted that we had pressed these arguments based on the evidence at trial. And, we came forward and said, here's the reason why these relate back. The county's been taking out these policies, for long beforehand. And in fact, a number of the same policies for which it seeks damages, we were recommending those policies. We renewed those policies while 02 and 03 agreement was in effect. And the district court recognized we were making those arguments. And, its response was too bad. Unfortunately for Hub, I can't hear that argument because this court decided, foreclosed that issue in its prior decision. And so the district court heard what we were saying. We made those arguments, and it said, unfortunately, I simply can't address them because of the law of the case binds me.
We gave you a 5-day trial, didn't we?
Yes, Your Honor, you certainly did, and we appreciated that, and that's why, we believe that the evidence produced at that trial should have been considered by the district court. That's exactly.
Well, the district court gave you a 5-day trial, and they wrote an extensive opinion. We wrote an extensive opinion. And,
the district court did. It gave us a 5-day trial. It heard us out on most of the issues.
Indicated he understood the opinion. Well, you're trying to, I guess, since I was the author, you want me to say, I don't think he did.
Well, Your Honor, respectfully, arguing with the author of an opinion about what he meant is a losing battle, and
I'm the denominator here.
I respect that. I can only give you my reading of.
I understand. You need to represent your client. This thing's been going on for, what, 4 or 5 years?
Yes, Your Honor.
You haven't filed a responsive pleading.
Well, that's because we had a right to seek arbitration before filing a responsive pleading.
You were able to take an appeal from the initial ruling on the arbitration issue because that's available by statute. It's reviewable. And you got it. And you came up here and we pointed out that you were entitled to a trial. We gave you the trial. And you had a trial. You had 5 days of trial. And now you're on another interlocutory appeal, basically, back again. And there's been no responsive pleading. And this is, it's a pretty substantial case. And then Judge Norton said twice, arbitration doesn't apply unless you can get us to change it. And you aren't even contesting, you said, the latter years.
Well, exactly for that reason, Your Honor. We appreciated that we got the trial we asked for.
No, it's a partial interlocutory appeal or something.
We appreciate that.
Whatever it is, but at some point, the merits of the proceeding need to be focused.
Well, Your Honor, that's really all we were asking for. We appreciated, we got our trial, we put our best case forward. The problem was.
That was the trial on the question of the arbitration issue. There's no trial on the merits. You haven't had an answer. You hadn't had discovery.
Well, respectfully, part of the time was due to the fact.
You didn't want that. You wanted to arbitrate.
A lot of the delay was based on we got an erroneous ruling in the first case. Judge Norton issued an opinion that this court found was erroneous. And, I don't think it can be held against us that.
That might be mischaracterized a little bit, I think. And I'm going by recollection. We said that there's some factual issues and that what is Section 4 permits a trial to resolve those. And we sent it back to have that trial conducted. And he conducted it. He wrote an extensive opinion about it.
Yes, Your Honor. And
And you're back again on part of that.
Yes, we got our trial, and we respect that Judge Norton decided a huge chunk of this case, and we respect that decision, and we're not appealing. We are not trying to create ticky-tack arguments to go and appeal what we think is, would have been a difficult case given the standard of review. However, we went back for a decision based on the evidence. That was the point of the trial, and the problem is with respect to this one critical part of our case, the judge refused to consider the evidence. It was like the trial never happened with respect to the 02 and 03 agreements. The court said, you presented this evidence. I'm sorry, I'm not going to consider it. So yes, we went back for a trial, but at the end of the day.
You don't like the result.
Well, we don't like that the court didn't consider the evidence. If the court had considered our evidence and ruled against us on the merits, we might be in a different place. But the law is clear that the law of the case, which was the basis of the court's decision with respect to the 02 and 03 agreements, does not apply when the court is presented with a different record at a different stage of the case. And this court's decision in Dillon v. BMO Harris is on point. There, the court denied a motion to compel arbitration based on the pleadings. The party came back to the district court and supported its motion with evidence. And the district court said, like the district court here, I'm sorry, I can't consider that. My prior ruling was law of the case. And this court reversed. It held that the law of the case didn't apply, and the district court should have decided the issue on the merits based on the evidence. And that's exactly what we're saying the district court should have done here. Regardless of how it read the prior decision, this court's prior decision was based solely on the allegations in the amended complaint. That's the whole reason this court sent it back, was because the prior decision had been issued on allegations rather than evidence. That's why this court sent back for discovery and back for our trial. But when it was...
Well, it's the same, it's the same evidence, right? The complaint alleged, specifically with respect to these damages, right? The complaint included everything that you're relying on now, except some testimony came out that confirmed that some of these damages actually were related to before 2005, right? Were arguably during the 2003 agreement. Is that right?
So there was
But the exhibits, the complaint alleged the number, the exhibits attached to the complaint specified those numbers and what they were tied to. But the fact that it took the 30B6 witness to kind of clarify the timing.
Exactly. We had a spreadsheet attached. We had an extremely hard to read Excel spreadsheet, one of those that breaks across multiple pages where you're trying to piece it together. That included some of the damages allegations that we're putting front and center because they clearly fall within the 03 agreement. But we needed some confirmation of what those were. And among other things, some of those payments actually fell outside the period of the, of the 03 agreement. But their 30B6 witness testified that, yes, well, even though we paid for it later after that agreement expired, the decision to renew it took place while the 03 agreement was in effect. And it's that decision to renew that's the conduct that is, the supposedly wrongful conduct, the supposedly negligent conduct, the supposedly negligent misrepresentations, the supposed breach of fiduciary duty on the non-kickback related claims. And that just confirms that the testimony then, we knew. We could say, all right, look, this decision was made back here, even though that damages figure you're putting out here is. And also, respectfully, I don't think that, when the court was commenting, this was not really the issue in the prior appeal either, where the question was, should it have been decided based on evidence? Should it have been decided based on allegations? And there were the definitive issues about, sort of what was alleged. All the things that were, decided back at the trial were not what were up and being argued and actually being decided before the court in the first appeal. I see my time is up.
Thank you, Mr. Patillo. Mr. Barber.
May it please the court, Philip Barber representing the plaintiff appellee, Berkeley County School District. Your Honors, this appeal is really about what I think was a surprising trial. We went back and we had the trial that was asked for, and I don't think the result was what either side really thought. We thought that there would be maybe some evidence, maybe a signed version of the 05, 06, 09, or 2011 agreements to be found. Maybe there would be some correspondence indicating assent to one of those agreements. Maybe there would be some evidence of assent by performance. And what turned out to be the case was that the 06 and 09 agreements were not even with the school district. The 05 agreement was merely an exhibit to a failed RFP response, and the 2011 agreement was well after Stanford Corney, the employee of NOF, now Hub, was sending checks bribing Brantley Thomas, and the invoices of that went to his home. And for many reasons, that was not a valid agreement. So Hub is really left with the 2002 and 2003 agreements, which are valid agreements. Hub has to somehow pull subsequent conduct under those agreements, despite this court's prior decision, which says, quote, those agreements predate the steering and kickback fraud scheme and conspiracy alleged in the operative complaint. So,
Is the complaint still the same?
yes, Your Honor.
The same complaint is the same, that operative complaint that we referred to.
Yes, Your Honor, and the district has argued in the briefs it would take an amended pleading to change the allegations. The court's statement that I just quoted was not based on an assumption that the allegations in the complaint, the operative complaint, are in fact true. I mean, possibly there is no fraud scheme at all. They're based on the allegations are what they say they are. The terms of the agreements are what they say they are in the agreements. Evidence can disprove those allegations, but it doesn't, you can't add or subtract allegations from the complaint based on evidence developed at this trial. And I would like to point out that,
Well, the purpose of a hearing is to, a trial is to hear evidence or attendance from witnesses, right? And you're saying that the court is in a box that I have to, or it has to ignore evidence that was garnered under oath? And because the pleadings sort of cabin this whole case, that's what motion to dismiss seemed for. But trials are to determine, it's an organic thing. It's to find out, it's truth-taking. So you're saying that the court was restricted from, could ignore it? Because otherwise it would be a farce to have a hearing if that's the case. The whole idea was to determine whether or not there was, what evidence is, and your colleague on the other side says, well, we say there are things that are related to conduct that was related back to the 02 and 03, and the facts were developed that suggested there were. So you're saying they can't because it's over, because it wasn't in the pleadings?
No, Your Honor, absolutely the court can consider evidence, and that is the point of the trial. What I was trying to state is that the allegations in the complaint do not change. Evidence does not amend the pleading. The allegations are what they are, and the trial reveals truth. Is this allegation true? Is it false? And your question, Your Honor, does pull a phrase that is used in the briefing by Hub a lot, talking about, I believe it's the conduct relevant to the district's claims, and trying to put a time frame on that. But as an example, Mr. Percorny was hired by Knopf, now Hub, in 2001. And he brought his book of business, including the school districts, with him. That hiring, I would think, is relevant in some way to the district's claims, but it would not be accurate to say that the district now is basing the complaint alleged on conduct in 2001 just because that has some relevance. The alleged scheme is what the complaint says it is, a scheme beginning in 2005. And even if there is new evidence, well, what is that new evidence? Hub alleges two things, or argues two things. First, these invoices that I believe it was Exhibit D to the amended complaint as a vendor detail report. It erroneously listed, I believe, 7 invoices that were dated because the clerical staff who pulled the report picked a cutoff date after the end of that 2003 PSA, but some of those invoices were for past services that occurred in that time.
Right.
That was an error, as explained in the briefs, and there has been, to the extent it would be relevant, I believe it would be relevant to a motion to dismiss on the merits if the damages that claimed are not supported. The second thing was these lines of insurance that had pre-existed in 2003, 2002. They existed back in 1996 and before. In fact, to take the inland marine example that is discussed at length in the reply
I don't
brief.
want to cut you off, but my point is this. You raise great points. I mean, absolutely. That's what great lawyers do. You argue those points. But their question before us today, as I understand, is that the district court just categorically said, I'm not going to even look at that because if the fact that it was these things that happened in the subsequent years, the 02, 03 predated that, and categorically, what they're saying is that we believe we've put evidence forward that show that they are related to, they don't have to be under it, but if they're related to arbitration, arbitrable, because they're related to those things, and the court didn't look. It doesn't mean you're wrong, but his point is that you're not the person who has to make that decision. The district court should not, and I don't mean this in a pejorative sense, but put blinders on itself, said, I'm not categorical, I'm not going to look at that because I understand the previous decision from the Fourth Circuit is that I can't look at that. That's foreign territory. We can't deal with that. But is that really the reading of this court? Because I'm at a disadvantage. I'm only one on the panel today who was not on that. So my good colleagues were there, and Judge King wrote it. But it seemed to me it was not a fixed point. At that point, it seemed like these contracts, it predated. But why wouldn't they have an opportunity at this trial, the 5-day trial, to say, yes, they are, and under the rules that this evidence was relevant, and you make good arguments say it's not. But the court said, I'm not going to look at it because I cannot. That's the question. Was it right that it could not? Not that whether or not the evidence was there, but that what it could not. Answer that. Why could isn't that an overbroad reading of this opinion from the Fourth Circuit?
Your Honor, I do not believe that is overbroad opinion. There was no new evidence that undermined what this court said, not just that they predated, but that those agreements could, at best, the June 22 and June 2003 agreements might be relevant to questions of whether Berkeley County Schools had knowledge of or assented to the subsequent agreements. Nothing was presented at trial that undermined that. The only thing argued here has been the invoices I talked about previously and some lines of insurance that, of course, the school district had during those periods and before, because there's a state's.
Why don't the invoices? Why don't that? It's It's almost $2 million, right? It's $1.5 million for policies and then some payments under the 2003 agreement. Why doesn't that change the evidentiary landscape from what was in front of the court before? Before we had a complaint and exhibits, and then when you went back, there's testimony about what those exhibits mean, and that some of these claim damages come from before the time period that the complaint suggested. And I mean, do you agree that you can't have it both ways? You can't both have damages for conduct that occurred in 2003 and related to that agreement. You can't have that and not be bound by the arbitration agreement in the 2003 contract.
Well, Your Honor, actually, I would agree with the point that you're making, though I would actually have to disagree about not being bound, but for a separate reason that hasn't been discussed, the RFP dispute and the settlement from that.
Sure, it would be up to, you'd have to decide whether those agreements actually, how they bind you. But you would agree that you can't have it both ways. I was a little, your brief suggested that you thought, this is just damages, it'll come out in the wash and we can, maybe they won't be liable for this amount. But it matters, because the allegations matter, because whether you're seeking that amount related to that time period, those two things run together, right? The 2003 agreement and damages for actions that occurred under that agreement run together, and you can't kind of get the benefit and not the burden, as it were, unless, as you say, you have an independent defense to that.
Yes, Your Honor, I would certainly agree. You can't have it both ways. And I tried to say in the briefs, to the extent the damages include those 7 invoices, they're simply wrong. If, just as a simple example, if someone alleges an injury and then attaches to the complaint alleging that injury erroneously an invoice for, say, a medical bill or something that predates the injury, that's just an error. And if that's all that person had to support damages, then it would presumably be dismissed on a 12b6 motion because that's an element, right? But it doesn't change the alleged injury to have a clerical error on a spreadsheet.
Well, no, it's not. It's damages for a certain injury, right? For an injury that occurred before 2005 in relation, potentially in relation, that might be up for an arbitrator to decide, in relation to these other agreements.
Your Honor, I would say that those listed invoices are not descriptive of the injury. They're not describing the injury. They are included erroneously in a spreadsheet itemizing damages that are alleged to follow from injuries that are described in the complaint.
Is there still time or opportunity for you to amend again, or has that ship sailed?
Your Honor, that's would be a question for the district court, but I would expect absolutely yes. As Judge King noted, there's been no responsive pleading. There hasn't even been a motion to dismiss. And since this amended pleading was filed, there has been, I believe it was 2 years of discovery, at least a full year of discovery, 10 depositions, a 5-day trial. So it would, I believe, be reasonable, since we learned a lot about the case during that process, to incorporate that in a pleading before we were to engage in, litigating the merits of the case. We should base that on what we know now. So absolutely. And if I could maybe segue, since it seems related to the settlement of the RFP dispute. So after those valid agreements, 2002, 2003, in which nothing, and this was something that we just, I think, maybe discovered, nothing untoward happened under those agreements. They were reasonable, everything was normal. They were a process set up by Mr. Brantley Thomas's predecessor, Ken Coffey. Everything was fine. After those, the district put its business out to bid, pulled the bid. There is a 2-year gap in any payments of fees to NOF, so the relationship is over. There is a threatened litigation over the way the RFP was pulled. There's a settlement agreement based on that, and that settlement agreement, the court found, I believe, concluded paragraph 147, expressly terminated the prior agreements, the 2002-2003 ones. Hub's reply, initial brief didn't mention that at all. The reply brief denies that until the end. I think the last footnote finally, recognizes that conclusion by the court and essentially argues that it's wrong. And I would think that perhaps that is a bit late to assign error to one of the conclusions that the opening brief said were not being challenged. But regardless, the language of that paragraph 6 of that settlement agreement unambiguously provides that all disputes between NOF and the district shall be resolved in a judicial forum, the Berkeley County Court of Common Pleas. It is not limited to disputes related to the settlement agreement. The brokerage service agreements, on the other hand, their arbitration clauses are specifically limited to disputes related to those agreements. This settlement agreement was for all disputes whatsoever between the district and NOF. So now, putting aside any sort of statute of limitations issues, if the district thought that NOF hadn't performed some services paid for that were under that 2003 agreement, it could not be arbitrated unless the parties made a new arbitration agreement. And if the Hub believed that some money was due under that, the arbitration clause clearly would not apply. It could not go to arbitration. There has been a subsequent agreement that it would be resolved in a judicial forum. We could not bring a breach of contract claim if we on that would be sent to arbitration. There's an agreement that that dispute would go to a judicial forum. I don't see how it is logically possible to argue that the arbitration clause in that terminated agreement that can't apply to disputes under that agreement somehow applies to other things years later, separated in time by years, that are unrelated to that agreement, except sharing a common subject matter. And to the extent that it appears that Hub is arguing that there's some special quality to the arbitration agreement, that it somehow survives the termination of the container agreement, I would argue that violates the Henry Sheen case that they rely on heavily, because arbitration agreements are treated on equal footing with any other contract. They don't have some special ability to survive an express agreement to terminate a contract, there was paid cash consideration for that agreement. So it is a mystery to me how, say, damages in 2007, 8, 9, 12, 14 could be subject to an arbitration agreement in a contract that you cannot bring a claim under that contract and have it be under the arbitration agreement because it was terminated. They agreed. We paid the money, and they agreed that was terminated. So that was a new finding at the trial, right? That was something new, and to the extent, perhaps, if the court should have considered new evidence. Well, it did make a conclusion on that. It did find that those prior agreements were terminated before the alleged conspiracy that's issued here. So that is in the judge's findings, and it was not challenged until the last footnote of the reply brief. So I just cannot see how HUB can overcome that express disavowal of arbitration in favor of a judicial forum. If the court has no further questions, I thank the court for its consideration.
All right, thank you, Mr. Barber. Ms. Patel, you have time reserved.
Thank you. I'd like to pick up by addressing this 2006 settlement agreement. The reason that this was not addressed in our opening brief is because it has absolutely nothing to do with this dispute. The 2006 settlement agreement concerned a dispute when the county canceled a 2005 request for proposals for insurance in its insurance business that had nothing to do with the 02 and 03 agreements. The county agreed to pay HUB a commission on certain policies going forward, and HUB agreed that it had no other claim for commissions, fees, or other charges than provided in the settlement agreement. My friend got up and said that it expressly terminated the contracts. I invite you to look at the joint appendix, page 139, see if there's any mention of it terminating any prior agreements.
Yeah, that was my understanding too. It didn't touch it at all, but go ahead.
And just to pick up on some of their theories, my friend again said that in this agreement we had agreed that all disputes between the county and HUB would be decided in Berkeley County Court according to the dispute resolution provision. If that's the case, why didn't they bring this case in Berkeley County Court? If we were somehow, defining all the terms of the parties' arrangements going forward, then they shouldn't have brought this case in federal district court because that's contrary to the 06 agreement. If the 2006 RFP settlement agreement wiped the slate clean and we got rid of all obligations between the parties and agreed that this payment settled all further disputes, then the implication of that would mean that all of their claims for damages from 04 and 05 up until the January 31, 2006 settlement date of this RFP should have been released by that agreement. And the reason, no one argued that because it's simply silly. There's no relationship between, other than the parties, other than that it was between HUB and the county and the subject was an insurance dispute. They have nothing to do with each other. And, if we were to find that this somehow wiped the slate clean, that this is in the wrong court, they've overstated their damages by millions because the 06 agreement would have released all of those claims against HUB. So, there are reasons why we didn't raise this because it has nothing to do with this dispute. Also, the notion that the district court made some sort of finding that this terminated the agreements, once again, I invite you to look at the district court's decision and see what it actually said. The district court did not make any finding anywhere that the 06 settlement superseded the 02 and 03 agreements arbitrations provisions such that they were irrelevant. The district court's holding with respect to the 02 and 03 agreements was, sorry, law of the case. I'm not addressing this. I mean, if it had found that that it wouldn't have needed to reach law of the case. It would have decided this on the merits by saying the 06 agreement, terminated that. That's not what it found at all. The district court said what it would look at was just whether they were evidence of the county's assent to subsequent brokerage service agreements. Now, what the court did find is that with respect to the 06 settlement agreement with the RFP was that because of that, when it was looking at whether the 02 and 03 agreements were relevant to the county's knowledge or to its later assent to the later unsigned agreements, it said, well, I find that to be weak agreement of assent to the later agreements because, we had this dispute and at the time we switched the county's property and casualty lines of insurance as part of this botched RFP process that the parties settled over. We moved, a bunch of insurance lines that had been by private insurers. We moved those over to South Carolina's IRF, which is a public insurance fund. And so it said that, for those purposes, it looks like there's sort of, there's a break in terms of when the coverage got moved over. It didn't say anything about terminating prior agreements. It didn't say that everyone is hereby absolved of any obligations they had under prior contracts, and it just doesn't speak to this at all. Even if you were to look at the dispute resolution provision in the '06 agreement on its face, it mentions disputes arising out of or relating to the settlement agreement itself. And again, there is no argument in this court or relevant to their claims that we are seeking to have arbitrated that has anything to do with performance under the '06 agreement. And as I've mentioned earlier, were that actually the issue, then there would be a whole lot of issues about their performance by bringing this in the wrong court and by suing us for millions of dollars of damages that would have been released under their theory of what this '06 agreement now supposedly means. So I'd like to just I have 2 minutes left. I'd just like to really quickly turn back to a couple of statements that were made before. So one was that on this issue of Judge Rushing asked a question about the spreadsheets and what was known at the time. And I believe counsel said that the invoices were not describing the injury. That's one reason why we needed to go back at the trial and tie back those allegations of damages to what is the conduct that relates to those. And so we tied that back there. That's one more reason why the evidence was relevant later. Also, my colleague said, the complaint didn't change, and it is what it is. And I think the court has fully grasped, the issue with that about trying to have its damages claims both ways. But I'd also like to just say the complaint itself doesn't, accepting it as true, and if you set aside the damages claims, it just doesn't address the question. It alleges when an alleged bribery scheme supposedly started, and it said at least 2005. The complaint is completely silent as to when the other conduct concerning its other claims for negligence, for negligent misrepresentation, breach of fiduciary duty, it doesn't speak to that at all. It doesn't say this didn't start until a certain time. It's silent. So whether or not the complaint, says what it says, it doesn't answer the question. And this court has held, time and again that when, an arbitration.
Doesn't that kind of take issue with our previous opinion?
No, Your Honor. I believe this court clearly stated that the kickback and bribery scheme, that the kickback and bribery scheme alleged in the complaint did not occur until after the '02 and '03 agreements terminated. And that's, we're not taking issue with that. That is what the complaint says. But that left open the question of when, I see my time's up. May I finish answering your question?
Yes, you may.
That doesn't answer the question of when the other conduct that is not premised on kickbacks, that is not premised on bribes, that is not premised on conspiracy, that is just premised on Hub's alleged failure to comply with the professional standard of care in providing insurance services, what those claims relate to and when that conduct occurred. And so we don't think that either the complaint or your prior decision answers that question. They both address the bribery and kickback scheme, but not other conduct that is at the core of their complaint and that they allege will support their entire damages amount. So thank you, Your Honors.
Thank you. Thank you both for your arguments. We can't come down and greet you as we normally would in our Fourth Circuit tradition, but know very much that we appreciate your arguments and your being here. We wish you well and stay safe. Thank you. We'll proceed to our next case.
court. I'm John Sheldon. I represent Christopher Coleman pro bono in this case. As Judge Gregory has mentioned, trial is about truth-taking, and the issue in this case is that Christopher Coleman's sentencing proceeding was entirely false. The legal standard for this ineffective assistance of counsel case is that trial counsel's performance was deficient, and there's a reasonable probability that if he was not deficient, Coleman would have received some other sentence than the 29 active years. At habeas, there was really no dispute that trial counsel's performance was deficient. The only issue was whether Coleman was prejudiced by the terribly false presentation at sentencing of Coleman's juvenile, military history, and medical history. The crime was a bad crime. Coleman returned from Kandahar, Afghanistan, and shortly after returning, in a drunken state, was invited into the home of a young lady. She opened her safe, took out her opioids, took some. In her safe was a gun. Coleman was showing her the gun. The gun went off and shot her once. She was seriously injured by that. Coleman was arrested. Shortly thereafter, same day, they released him. They released him because it was not an intentional shooting. They released him. He continued drinking. He went straight to a bar with his friend, drank all day long, got in a bar fight, broke the ankle of another person at the bar. Charged in the city and the county with both crimes, malicious wounding in the shooting, malicious wounding in the bar. He pled guilty. It was obvious what sentencing was going to be about. It was going to be about Coleman and how he could, after having accidentally shot somebody, been charged by the magistrate, how he could then go drinking and then get in a bar fight. It was going to be about who Coleman was and how much time he deserved in prison. That was obvious. And trial counsel came up with a strategy, and his strategy was to present Coleman as a man with no prior criminal history, who had been a war hero and deserved sympathy even though he had committed these two acts. The problem that trial counsel made was he presented this scenario about Coleman, no prior criminal history, seriously wounded, PTSD and traumatic brain injuries. He presented this evidence in the worst way possible in a court, whether at trial or at sentencing. He presented it solely through his client's testimony. And because trial counsel didn't prepare, he couldn't support his client's testimony with easily obtainable, objective evidence of Coleman's very difficult, being the victim of problems as a juvenile, his compassionate and good behavior as a juvenile, his traumatic brain injuries, 2 of them, his PTSD, and his heroic efforts. He supported Coleman with no documents. The Lewis Gale medical records, which prove that Coleman had PTSD and traumatic brain injuries, were retrieved from a hospital only miles from the courthouse. Ms. Berry, the probation officer who testified at the evidentiary hearing, that Coleman had no juvenile history at all, and all of his misbehavior was to get away from an abusive home, and he was in fact the most compassionate man that she had ever supervised. She worked in that court. She was easily available. Colonel Gaylord testified both to Coleman's heroic acts in Afghanistan and to his physical injuries that the court found did not exist. Physical injuries, shrapnel injuries, traumatic brain injuries. Colonel Gaylord was
Just on that point,
Yeah.
some of this is what Coleman himself told probation, right? He told probation that his health was good, he didn't have any ongoing injuries or effects from his service, that he didn't have any sort of previous record, et cetera. Some of this, what he said then came back and he was crossed on it, not necessarily because there weren't records, but it seemed that he had said one thing, and then at this subsequent habeas hearing was saying another.
I hear you, Judge Rushing, but I don't think that's the case. I think what happened was he talked to probation, and in both during sentencing he testified and at the evidentiary hearing. And he explained it, and Colonel Gaylord explained it too. He said, this is what...
The evidentiary hearing in the post-sentencing habeas corpus proceeding.
Yes, Your Honor.
All right, but you're talking about sentencing.
We're talking about sentencing mainly,
Original
Judge.
sentencing.
Yes, that's right.
Yeah. And it was for the same judge, right?
Yes, Your Honor.
Years apart,
5 years apart.
5 years apart. And that's in the Circuit Court of Roanoke County or Roanoke City?
Combined. We had the hearing in Roanoke City, but it was combined, two
So
cases
that's the
combined.
way they're set up, it's joint. The distinction is not making any difference. Okay.
Yes.
The same circuit court.
Yes, Your Honor.
So you had the sentencing there, 5 years later you had this hearing, and then you have the federal proceeding in front of Judge Moon.
Yes, Judge King.
Were there any evidence presented in front of Judge Moon?
No, Your Honor, we
All
didn't
the
get a
evidence
hearing.
was presented in the state habeas proceeding.
Yes, Your Honor.
There you go.
Answering your question more directly, both during the sentencing hearing and the evidentiary hearing is important for this reason. Colonel Gaylord explained why. Men from
Gaylord was a
military.
commanding officer in Afghanistan.
That's right. His commanding officer, who Christopher Coleman's main job was to protect him
Was
in
he
Afghanistan.
Special Forces?
What's that?
Was Colonel Gaylord and your client in the Special Forces unit?
I think that's over my head of what unit they were in.
They were from Fort Bragg.
Yes, that's right. That's right. And so when Coleman gets home, he does what the vast majority of military people that come home with serious injuries do. He ignores them. He ignores his PTSD. He ignores his TBI, and he tries to get away.
He was hospitalized at Womack when he came back.
He was hospitalized, and then he was released, and he was told,
At Fort Bragg.
yes, that's right. That's
He had a
right.
head injury,
That's right, Your Honor.
2 concussions at least,
2 traumatic brain injuries,
2 traumatic brain injuries at least.
2 of them at least, as well as shrapnel
Diagnosed
injuries.
by the Army medical, by the military medical services.
Yes, Your
And
Honor.
before that, though, he'd been in the hospitalized in Qatar,
Yes,
in the military hospital, for these traumatic brain injuries. And he'd been hospitalized in Germany,
yes, Your Honor.
at our Army hospital in Germany,
That's right.
and then transferred back to Womack.
That's right. And the sentencing court knew none of this.
And Womack's Fort Bragg.
Yes, Your Honor.
And you know how, was any of that presented, none of that was presented at the sentencing?
None of it.
And you got into it with the,
Easily obtainable.
did you represent him at the state habeas hearing?
Yes, Your Honor.
The state habeas hearing,
Yes, Your Honor. I represented Coleman in the state habeas hearing.
and you represented him in the federal habeas proceedings.
Yes, Your Honor.
So you've been with him, but you didn't represent him at the sentencing.
And I'm with him now.
You're with him now.
for other reasons and this, but yes,
Yeah, you're
I'm with him.
with him now. You've been
It's
with
very hard to have PTSD in prison.
But the sentencing hearing is where you're,
That's where the mistakes were made.
that's where the mistakes were made by the previous counsel,
That's right.
and he acknowledges that he didn't do.
That's right. It wasn't in dispute
Does
for
he acknowledge
anybody.
that he was constitutionally insufficient in his view?
Yes, and nobody disputed that.
Well, then
That he presented a theory for a very
the
important.
only issue for us is the federal, whether the federal standard is satisfied
That's right.
on prejudice.
That's right. Reasonable probability that if the truth had been told, he would have got a sentence other than 29 years. But
Isn't the standard actually that no reasonable judge could conclude?
gloss, right?
Right.
First, I have to show the constitutional violation.
Right.
Of prejudice, and then I don't win unless I also show the 2254 D1 and 2, either one, unreasonableness, right? And of course, if anybody can make sense of the law, 2254 D1 and 2 law, the 25 years of U.S. Supreme Court cases, they say one thing, they do another. In Porter and Wiggins, They look at it and they say, of course there would have been a different sentence, go back. And then, of course, we have lots of language that's quite harsh, it's quite hard to get over, and I think we easily get over it. And that's because it was obvious why, I'm going to take one more minute because I haven't answered your question yet, of why Coleman said to the probation officer, one, I don't have a criminal record because he didn't think he did it, and two, he glossed over his injuries because that's what military guys do, and that's how they get into trouble, and that's what Colonel Gaylord testified so compellingly to. He said, that's what we do. We're tough guys. We go, we kill people. We come home, we say we don't need help. But it was obvious by the time he got to sentencing, it was obvious for a lawyer that he had brain injuries. He had told his lawyer. It's obvious he had PTSD. So that was brought out at sentencing. But because Coleman, this is the terrible part of the case, because Coleman was made out to be such a liar, nobody would have believed the good stuff he said.
Is that true? When I was reading, I saw the court said it didn't find his statements of remorse credible, but I didn't see the sentencing court saying, I didn't find anything else he said to be credible.
Well, I think it's a short sentencing transcript, and I think if you look at the probation officer's testimony, and the prosecution 4 times makes him out to be a liar, right? Twice to the probation officer, the prosecutor asked probation officer at sentencing, he told you he didn't have a criminal history, didn't he? But he had an extensive juvenile criminal history, and the probation officer says yes.
And then Mr. Coleman explained, right, that the reason I said that is I thought it was expunged, right? The sentencing court heard that.
He heard that, okay. But why they believe that, I don't know, because the probation officer said he has an extensive criminal history. Then the prosecution...
Probation officer said he had an extensive criminal history, and that was based on the juvenile record?
That's right, and it was entirely wrong.
Expunged.
Entirely wrong. He had no criminal history.
He said it had been expunged.
He did say that.
He told his lawyer it had been expunged, but his lawyer didn't go check it out.
That's right. And he was cross-examined. So first the probation officer says he lies about his criminal history. Then the probation officer says, well, he did say he had an injury. And the prosecution asked the probation officer, did you find records to substantiate that? No, I didn't. And then when Coleman testifies, the prosecutor asked Coleman about both things. You lied about your criminal history. He's been told by his attorney...
They impeached him on the criminal history?
What's that?
The prosecutor impeached him on his criminal history.
On his criminal history, and then...
Expunged.
That's right. And then...
Did the prosecutor not know they'd been expunged?
Correct. Nobody had known that, 1, he'd never been convicted, 2, they'd all been dismissed, 3, the record had been expunged.
Did the prosecutor impeach him on the history or on the fact that he said he didn't have one?
I'm afraid I'm going to run out of all my rebuttal
You
time.
may answer the question. We're not going to ding you on that. Go ahead.
Okay. Would you repeat the question, Judge Rushing?
I thought the prosecutor impeached him on the fact that he said he didn't have a history, didn't impeach him with the juvenile records, right? The prosecutor didn't come in and say, why should we trust you? You have all of this criminal history. The prosecutor said you didn't have it.
Correct.
But it turns out you do. And he explained, yeah, I said that because it's been expunged.
Because I thought they were being expunged, but it was accepted by everybody at sentencing that he had a criminal history.
Right. It was impeachment about the truthfulness of his statement.
Yes, which I think is worse. And also what's worse...
But it's not impeachment with a criminal history. We understand that's a different thing.
You're absolutely right about that. And then later, when he testified, he was impeached by the prosecution on cross on both things. You lied about your criminal history, didn't you? Yes. You lied about, well, you say you had these injuries in the military, didn't you? But there's no documentation of them, is there?
Did the prosecutor use the term lied? You said
I think page 289 and 291 of the appendix. If he didn't use the word lie, that's exactly what he meant. 289 and 291 of the appendix. Coleman was shown to be a liar.
Did he use the term misrepresented?
Well, I'd have to turn to those pages, but it's clear that that's what he was doing.
He had juvenile problems, and they had been expunged. That's the fact of the matter.
Dismissed and expunged, no convictions.
Correct.
That's right. That's right.
His lawyer didn't know that.
The lawyer didn't know
Didn't know that.
It was so easy to find. The probation officer was right there.
Serious medical problems, brain injuries.
That's right.
And that was a fact.
That's right.
And it wasn't known.
And so because the lawyer didn't
He was
know,
impeached on it.
Because the lawyer didn't know that he didn't have a juvenile history, he was faced with his pre-sentence report that literally said,
Saying he had you said the prosecutor impeached him by, over where he said he had medical brain injuries?
that's right. Said, well, there's no documentation of them, is there? But because trial counsel had not discovered.
Are the military medical records been made available?
Yeah, they're in the appendix.
And they reflect his brain injuries.
Thoroughly.
His body was blown apart.
That's right.
And he picked up the pieces.
That's right.
And Colonel Gaylord testified to that.
That's right.
Colonel Gaylord said he's the best soldier I ever had.
Yeah. Yes.
Something to that effect. And he used him as his personal security man. Correct?
Yes, Judge King.
And when he was honorably discharged, he was automatically Service Connect in terms of veterans care, right? When he
Yes.
Automatically service, the purple card, right? Service Connect.
Yes, and Colonel Gaylord explained how people behave when they come home with those injuries. They don't take advantage of it. Can I just answer
One
your-
more question on
Yes.
the prosecutor. Again, having read the sentencing, I thought the prosecutor said the argument was even accepting that this gentleman came back from Afghanistan with problems, that I think they said he was messed up by being in combat. He was messed up by the things he saw in Afghanistan, et cetera, that even assuming that didn't excuse his behavior. That was the argument that the prosecutor made, right?
That's right. They disputed the fact that he had PTSD. They disputed the fact that he had TBI. But they did concede, maybe he's messed up. And so the judge found, and this is what he said, that considering your lack of compassion as a juvenile, your violent behavior, when there was zero violent behavior in his background, and seeing nothing else to explain why, this is what the sentencing judge, any judge would be stuck on. You're shot Miss Cook by mistake, you're arrested, and you go to a bar and drink and fight somebody? I can't understand that. We presented overwhelming evidence of what somebody does with PTSD and TBI, RE, substance abuse, and alcohol abuse.
And
lady
the
was
same
shot.
judge heard that and said it wouldn't have changed anything.
Well, maybe in rebuttal I can talk about that opinion, but I'm going to take another 17 minutes.
Judge King had a question, I think.
Yes, Judge.
The
So you're not
lady
answering my
that was
question.
shot was shot and injured very, very seriously. Terrible injuries.
Yes, but understand she had recently had.
And that's the primary basis for the long sentence he got.
I don't think so, Judge. She had just had abdominal surgery before this, and this is why she was taking opioids, right? Because she had intestinal surgery. I think the long sentence, reading.
But she's paralyzed, right? But she wasn't paralyzed from the abdominal surgery.
No, she wasn't paralyzed.
Right?
She walked to the witness stand.
He was
sat
terribly
down.
injured. There's
She
no
was-
question about
she was
that.
But the
injured.
judge was very concerned about the injuries.
Yeah, she was injured. She
Okay.
was shot through the side, through the abdomen, through the leg.
She needs someone to take care of her for
She
the rest
walked
of
to
her
the witness
life.
stand. Yes, she was badly injured. She was shot. I would not want to be injured like she was
She's
shot.
lucky she wasn't killed.
That's right.
And
But the judge
she was
clearly-
on a crime wave that night.
The judge clearly described why he sentenced Coleman. Lack of compassion and history of violence beginning to end. No explanation for why you might go and commit another crime after Cook. That is, he didn't hang his hat on these terrible injuries to Cook from this accidental shooting. It was, how could you go out drinking? If you have no other questions, I'll save the small amount of time I have left for rebuttal. Thank you.
Thank you, Counsel Sheldon. Ms. Johnson.
Good morning, Your Honors. May it please the Court. Victoria Johnson for the Director in this Section 2254 habeas matter. To start, the only question in front of this Court is whether the state court's judgment was reasonable under AEDPA, and I submit that it was. To start with some of the facts, and ordinarily I would not dwell on the facts, but I believe that it's important to remind the Court that Ms. Cook Moore, the county victim, was not shot accidentally. The record in no way supports that. I think that that is perhaps Mr. Coleman's version of events, but what he pled guilty to was malicious wounding. That's not an accidental discharge crime. That is a crime of malice. The facts reflect that, and this was found by the state court, and unless there is clear and convincing evidence that can rebut the presumption, that is presumed to be correct. The state court found that Mr. Coleman held
Which
this
state
woman.
court are you now talking about?
I'm talking about both the Virginia State Circuit
No,
Court.
but you had a
and the-
sentencing court and then a habeas court.
Both, Your Honor.
Okay,
This
the
was
state's
found-
court, so you're saying courts?
Yes,
plural.
courts, plural.
Okay.
Both the Virginia, and it's confusing in this case because it was literally the same circuit court. It was the same circuit court judge. So he was very familiar with these facts. But both the sentencing court and the state habeas court found that Mr. Coleman held this woman at gunpoint for a period of time, essentially mentally tortured her by playing Russian roulette with this gun, where it was unloaded and he would fire it at her. Eventually, he loaded the gun and shot her at very close distance and created these devastating injuries. I think that is a very important fact when considering the sentencing in this case. Additionally,
I think the
Mr.
important fact here is whether the state habeas court applied the proper prejudice standard.
And I submit,
That's the issue, is whether there was prejudice from the ineffective counsel from the Sixth Amendment violation. Did the state court apply the proper prejudice standard? I'd like to hear you focus on that. Tell us what standard was applied and whether that's the correct standard. And if it's not the correct standard, the one that was applied, what is the correct standard, and whether you're arguing harmless error?
the correct standard was applied. I'm not arguing harmless error.
What's the standard that applied?
The correct standard is the Strickland standard, which the state court faithfully applied, and is whether, absent assuming counsel's deficient performance, was there any prejudice, that is, any reasonable probability of a different result at sentencing? And a reasonable probability is a belief that that there's lack of confidence in the outcome. And I submit that there's several reasons why this was the correct result. And I think it's important that since this is a 2254 case, that this has to be a situation where if it's not just that this court thinks that the state court should have done something differently, it's that every reasonable jurist would disagree with the state court's judgment. And that's an awfully high standard.
It is a high standard, but let me go back to where you started. In terms of the malicious wounding he pled guilty to, was there any evidence that he had any animus toward this lady before this?
No, Your Honor.
Right. It was, that's the point. There was no reason for him to engage in the conduct that you just said.
And I will say, Your Honor, that this
Am I
was...
right? Am I right? There was no reason that he would have done that, the fact that he did, right? Like, I'm not disputing. It's not a trick question. I'm saying you laid out what he did. The roulette, she was shot, malicious wounding. But my point is, so, because, I was a criminal defense lawyer for a long time. And two questions is, did they shoot the person or do it? And the second one is why? And the second question is more important to the verdict than the first one is. Why? There's no why here, is there, in that case?
No, and here's why there's no why.
Okay.
There's no why because this was a guilty plea. And under Primo v. Moore, that shortened record that's created by a guilty plea does not inure to the benefit of a petitioner.
No, you're absolutely right. It doesn't benefit him, but it still leaves the question of there was no why. There was not money, there was not passion. The point is, isn't that why it was so important to have this information about him? Because it explains the extraordinary situation. I mean, you do this, why would you do this? That's when you need someone to say, well, Judge, because let's look at the framework of the person who came to this fateful and unfortunate day. That's why you need them. That's what the whole purpose is. Because when you got the why right there, well, because he robs people. Well, because she did him wrong. He had been threatening her for years. It's when you don't have that, that's when you need to fill the gaps of the human course of human existence. What brought this human being to this day to be sentenced for that? And that's what lawyers do.
And I agree with that, Your Honor, and that goes to deficient performance.
But so you concede that.
Yes, Your Honor.
And you don't think that's
Never.
important for the judge to know this person's, the depth of that? Not just, a sob story, but documentation of diagnosis, DSM-3 diagnosis, that's when you need that. And you're saying that the court was just sort of, well, I don't care that he went to Afghanistan and served his country and saw somebody blown away and picked up pieces and did that he just did this, and I don't believe that judges do that. I think that, I'm not talking about compassion, I'm talking about what individualized sentencing is.
I agree with the court that the defense attorney here should have put that information in at the initial sentencing. That would have been a much stronger, that would have been a better tactic for that defense attorney to use.
Tactic? No.
But,
Okay.
right, a better decision, right? He should have put it in. But it all came in at the state evidentiary hearing. This isn't a situation where the state court closed its eyes to that evidence. The state court said, bring in all the evidence you want me to hear, and I will hear it. And the court did. We had an evidentiary hearing in state court, and Mr. Coleman was able to bring in all the evidence that he could muster. And some of that evidence,
And the court said it doesn't make a difference.
well, some of that
Right, and the
evidence,
court said none of that made a difference.
that's correct, Your
So
Honor.
that means, so the question is, was that unreasonable?
No, it was not, Your
I mean,
Honor.
but that's what we have to decide.
That's right.
I just
And
want
my-
to get to the point that that's what we have to determine, that you could say, that would make a difference to me, that what he did in Afghanistan, what he saw, what his conditions were, none of that would make a difference. We have to just say that was reasonable, right?
That's correct.
Is
That's
that
the
right? Because
standard.
I thought he did present that story at sentencing. He just didn't have some of these documents we've talked about to back it up. He presented, all of this happened to me, this explains why, but the argument is, he just had his own testimony and a little bit of support. He didn't have all the other support that came in at the evidentiary hearing, right? So the judge is not saying, oh, it wouldn't matter to me at all that all this happened. The judge is saying, I already knew, and this extra evidence wouldn't have changed things. Am I right in understanding
Yes, Your
that?
Honor, you are right. And I think to be
You
more
already knew
clear.
what? Everything about the diagnosis and everything?
Well, Your Honor, I think that the record is clear that Mr. Coleman testified at the sentencing hearing, and he expressed
I'm not
that he
talking about the
had,
sentencing. It's one thing for you to say something. If your client did something, I mean, it's one thing for them to go, well, I'm really messed up and I've been having problems. The first thing you do as a defense lawyer, you want to say organically from an expert what his diagnosis is. It's always strong when it comes from someone else who's apart from you, because everybody says, well, I guess he would say this because it helps him. You need the buffer of science, the buffer of objectivity. I mean, I don't know how we just lose our sense of what lawyers do and what this truth thing is. It was like, I mean, I know your job is, it's always like your side always say you're the best lawyer that ever was. At least you are conceding that he was efficient, but it's amazing how smart you get to be with it in these IAC claims, the defense lawyer is. But it's different than he did, that he shouldn't be left alone. I mean, this is a case perhaps done, you probably wouldn't even have to put him on if you put things on.
well, Your Honor, as I've said, I believe that goes to deficient performance, and deficient performance isn't the prong of Strickland that's before the court. This prong of Strickland that's before the court is prejudice. And here, all of the evidence that, first of all, this is not a situation like.
You're saying the military records of this fellow wouldn't have made any difference anyway?
Yes, Your Honor, because,
I mean, that's what you're saying. That's what the state's saying.
yes,
You're entitled to say that. Absolutely, I agree with that. But I'm struck by Judge Moon's recitation. I'm on page 14 of his order or opinion about the military medical records. Reflect that Coleman experienced 2 traumatic brain injuries in Afghanistan within a 6-month period. During his hospitalization, he was at Lewis Gale in March 2011. He was diagnosed with PTSD. Military records corroborate his service history. At discharge, he had received the rank of E5. I don't know if you know what that is or not. I do. It's a it's the rank of a sergeant. An enlisted man are ranks of E1 to E9. So within 4 years, he was an E5, which is terrific progress. His DD 14, I think it means DD 214, which is a discharge record from the military, reflect that he earned awards, these awards during his 4-year tenure. Purple Heart, that's for being injured, wounded. Army Commendation Medal, Army Achievement Medal, NATO Medal, Army Good Conduct Medal, National Defense Service Medal, Afghanistan Campaign Medal, 2 stars. That means he was there twice, I think. Global War on Terrorism Expeditionary Medal, Iraq Campaign Medal, 1 star. Army Service Ribbon, Overseas Service Ribbon, 2nd award, Combat Action Badge. None of these records were introduced at Coleman's sentencing hearing.
Respectfully, Your Honor.
Let me finish. Coleman's trial counsel signed an affidavit acknowledging he was ineffective for failing to obtain any of these records. And he opined that his ineffectiveness resulted in a prejudicial outcome for Coleman. Now, that's a striking thing that we don't see very often in a federal 2254 proceeding. And that's Judge Moon, the district judge in Western Virginia, recited that in his opinion.
Was there evidence of those awards at sentencing?
Yes, Your Honor. At the original.
Did anyone doubt that?
No, Your Honor. No one doubted or
No one doubts it,
questioned.
but it wasn't presented.
It was
That's
presented.
what we're doing.
Your Honor, it was presented at the original sentencing hearing. The awards and service medals were presented at the
So you
original
think
sentencing
Judge
hearing.
Moon clearly erred?
Your Honor, if that was an error, it was certainly a harmless error.
So he says none of
because-
these records were introduced at Coleman's sentencing hearing. I'm not talking about the state habeas hearing. I'm talking about, he says they were not introduced at Coleman's sentencing hearing. That's when he got his sentence.
It was Exhibit D.
This
at
is Judge
sentencing.
Moon. You say
I'm-
that's clear error?
That is an incorrect statement. It was Exhibit
Okay.
D at
All right.
sentencing was a list
have
of the
you appealed?
awards.
You didn't, have you told us that the judge erred in the
No, Your
recitation
Honor,
of the facts?
because I'm not aggrieved, and that is harmless error.
Okay.
That would be the definition of
You're
harmless error.
entitled to say that.
Because this is a 2254 case. While this court reviews the district court's decision de novo, what matters is whether the state court judgment was reasonable under 2254. And reasonability does not mean whether.
You're saying the judge erred in saying that the trial counsel says he was ineffective and that there was prejudice?
No, the trial counsel said that. That's not something that's generally given great weight. I think that
sorry?
is, under Richter v. Harrington, that's not given weight, Your Honor. Whether counsel's ineffective is an objective standard. Counsel can feel bad and have bad feelings about that and admit to wrongdoing, but that doesn't give great weight. That was something that was certainly known to the state habeas court. And, Your Honor, at sentencing, Mr. Coleman testified that he had been in Iraq, and Afghanistan. He testified to his military service. He testified that he had been
His lawyer
injured.
said he put this in through testifying and they said he was a liar.
And he was
Wait, but
tested, right, by cross-examination, which is always going to happen. However, when they had the state habeas hearing, every bit of evidence that Mr. Coleman wanted to
Was this
put
put in
in.
through the DD-14? He says it's the 214, the discharge record? All these Army medals? And that was before the sentencing judge with the military records?
The military records as a whole did not come in at the
military
sentencing
records weren't
hearing.
there.
However, there was a list.
Maybe that's what Judge
I
Moon's
think
referring
so.
to. I'd say that's what Judge Moon's referring to. The
I'm not-
military records reflect this, and they weren't presented. They weren't presented. He testified, and they claimed he was lying.
Judge King, at sentencing,
That's what,
at the state court sentencing hearing, a sheet of paper came in with a list of the military awards and honors that Mr. Coleman had received at the state court evidentiary hearing. I do not at the moment have the app site for that, but I will certainly write a court with the letter of
Evidentiary
court.
hearing or the sentencing hearing?
The sentencing hearing,
Okay,
at the state court sentencing hearing. The full military records, every military record that Mr. Coleman wanted to put in, came in at the evidentiary hearing.
That's the
The
habeas
habeas
hearing.
evidentiary
That's the
hearing.
habeas corpus hearing.
Yes, that's right.
That's after the
Yes,
sentencing.
but some of
So that's
the awards and medals were disclosed to the state sentencing court in 2012.
And then came in, and then Judge Moon reviewed it, and he said, he accepted or found that there was ineffective counsel, but ruled in your favor on the prejudice prong.
He found that there was deficient
So what's on
performance,
the appeal
yes.
here is the prejudice prong.
That's right, Your Honor.
That's what we're focused on.
That is what we are focused on. And here, all of that evidence came in at the state evidentiary hearing, the habeas hearing, and Judge Dorsey in Roanoke accepted all of that evidence. He considered all of the evidence, and he determined that that evidence did not change his mind. That is not unreasonable. Some courts, I think possibly this court, would have given that evidence great weight. Some judges are not going to. And there's reasons in the record why the state court judge in habeas
And you
did
agree with
not-
me that the proper test is under Strickland versus Washington, whether there is a, and I quote, whether there is a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different.
That's correct, Your Honor.
Okay.
And this case is not like, for instance, Porter v. McCollum. In that case, there was significant testimony that came in, expert testimony that came in on habeas. We don't have that here. Here, all the evidence that could be mustered did not include any expert testimony explaining how that PTSD diagnosis or those TBIs at all affected how Mr. Coleman behaved. There was no connection shown in the state habeas proceedings. The expert testimony relied upon was a one-sentence affidavit that was completely conclusory by someone who was not an expert in PTSD. The medical information, and this is right about at Appendix 584, I believe, or 506, 504, from Kandahar, showed that after his second TBI exposure, which is the word used in the medical note, he had a head CT that showed normal processing, no abnormal foci, no concussion, no fracture. He was noted as having a normal level of consciousness and was calm and had normal speech. So while certainly these medical records and his history of PTSD and his horrible experiences, and I do not mean to in any way deny that those were horrible experiences overseas, no one has shown how that affected his behavior such that his sentence should be mitigated. Another thing, Your Honors, is that the state court judge at sentencing, way back in 2012, did not lay a lot of emphasis on Mr. Coleman's credibility. And I understand Mr. Coleman's position is that he was painted as a liar. Well, the court didn't really focus on that. The court said, I find that your expressions of remorse are not genuine, but didn't say anything about anything else. In fact, Mr. Coleman explained why he thought his juvenile record had been expunged, and he had joined the Army, which indicates that it had in fact been expunged. The sentencing judge back in 2012 knew that. There's no indication. I'm out of time. Can I wrap up?
Sure.
Okay, thank you. The sentencing judge knew that. Here, Your Honor, the question is whether the state court managed to so completely bumble, this is Mays v. Hines, this is the United States Supreme Court in 2021, completely bumbled such that every jurist of reason would disagree with him. I submit that standard has not been met, and I ask you to affirm. Thank you.
Thank you, Ms. Johnson. Mr. Sheldon, you have some time reserved.
Thank you, Your Honor. Regarding Mr. Coleman's commendations and medals, one two single pages were handed up at sentencing, at Christopher Coleman's sentencing. Exhibit D did not have his commendations. Respectfully, I disagree. It's at page 326 of your appendix. You can see Exhibit D. It's one page, and what does it say? It says he's been discharged. That's all it says. The evidence of his commendations came through his testimony, and you know what my opinion is about his testimony. He was so thoroughly impeached by testimony of the probation officer and by cross-exam that you're a liar about your criminal history, you're a liar about your medical history, your TBI and your PTSD, that everything else he said had this gloss of he's a liar, including whether he's remorseful.
Did anyone ask a question about the medals to call into question his testimony?
No,
I thought it was redirect. It was, he had his direct testimony.
Yeah, that's
He
right.
was crossed, and then his lawyer came in and on redirect gave this list of awards as sort of the last thing he said
That's
to
right.
the sentencing judge.
And nobody really cared about that. What they cared about is...
How do you know?
There's no evidence. Nobody said anything about it. The judge said a lot at sentencing. And I take that the judge cared about what he says he cared about. What he says he cared about is you have shown no compassion and have been violent from a juvenile to an adult. Wrong. You have presented us no evidence that there was any connection between, that you've shown me no evidence about why after shooting this person.
So you're saying the judge was wrong that he had a violent history?
Yes, absolutely, 100%.
What part of your habeas evidentiary hearing and this appeal has to do with that, discounting that?
Ms. Berry's testimony.
But how can what's the remedy? If you disagree with the sentencing judge's assessment of your client's history, but there's been it's not as though there weren't, if there had been more records, something would have been different about that part, right?
No, Judge, it would have been entirely different. Imagine at your sentencing when the probation officer says he's got a long criminal history, he's been violent, the prosecution sums up as violent, and you call the court's own employee who says, by the way, from the ages of 14 to 16.
Yeah, I see. This was in your brief. But you say there were people they could have called who said, I didn't know anything about him being violent. But they didn't disagree. They didn't say, oh yeah, that accusation that he was violent on X day is false. It's just that those people had a good opinion of him and didn't know about the other violence. It could have countered all I knew of him, he was a very nice, boy when I was supervising him. Right.
There was no allegation of violence that went unrebutted at habeas. Why they were calling him...
Sorry, I don't want to make this a sticking point, but no one came in and said he didn't commit these acts that were in his history, right? Just that the criminal history had been
mischaracterized.
May have been expunged, but the acts actually happened.
They were mischaracterized entirely, and so we did put on, and in fact, we didn't put it in our brief, but it's in the federal habeas and state because it's overwhelming about how all his behavior, because what his juvenile criminal history is not that he injured anybody ever. There was one felony charge that was dismissed and expunged that could have been considered violent, a breaking and entering where we proved at habeas the breaking and entering was he went into a frat house at night and drank a beer. That was his breaking and entering. And so why were they calling him uncompassionate and violent with a long juvenile history at sentencing?
He has this medical mental history that was kind of tied up with the mitigating evidence, right?
That's right. And mischaracterized entirely at sentencing and put into the proper context at the evidentiary hearing when the court's own employee who had been with him for 18 months during that time said it was his attempt to get away from the abuse at home. The alcohol use, his mental health treatment was an attempt to get away from abuse. He was the most compassionate man. When you look at the two, we might nitpick here and there, but when you look at his sentencing proceeding and you look at the evidentiary hearing, you can only draw the conclusion that the court had a complete 180-degree mischaracterization of this individual. Both as to his...
You were going to answer my question from direct, when you first stood up. You promised that you were going to answer on your rebuttal the question about the same judge. Does it make a difference that this was the same judge?
There's plenty of case law that says it's relevant. But I would say this about the same judge. Sorry, go ahead. Finish your question.
So the Supreme Court said if that person is particularly well situated to assess this sort of question. But I don't think we have a case like this. And so my question for you is, if this judge seemed to focus at sentencing on the crimes, right? The judge said, there's these Virginia guidelines, but they don't account for crimes like this. And then the judge hears an evidentiary hearing where they hear the additional evidence, and the judge says it wouldn't have changed anything. Does that have any additional weight, or do we just kind of assess it for ourselves?
I'd say this. I'd say what you're asking really is, does the state court's habeas opinion carry more weight because it was written by the same judge that conducted the sentencing?
Does its prejudice analysis, and that the
That's right.
entire prejudice question is, would the sentencing judge have done something different?
That's right. And I'd say it carries very little weight in this case. That's because, first of all, we know that the Supreme Court has said it's relevant. Nevertheless, it's an objective standard. But remember, there was 5 years between sentencing and this, and the judge had hundreds of sentencings. Also, in neither opinion did he make witness credibility findings. That is, he didn't say in the evidentiary hearing, I remember this witness as being like this, the things that you would normally defer to. And this is relevant. I understand that you're stuck with the opinion from the state court habeas, but it's relevant that he didn't write a word, that he adopted verbatim the entire thing from opposing counsel. And the U.S. Supreme Court has also said, this is a practice that provides a disservice to reviewing courts, especially in habeas, when a state court adopts verbatim 100% factual findings from an opposing counsel, especially, they said, when there is indicia of incorrect, objectively incorrect findings, and there are dozens of incorrect findings in that opinion that was written by opposing counsel. So I'd say a tiny bit of relevance that the judge was the same, Your Honor. If there are no other questions, thank you very much.
Thank you, Mr. Sheldon and Ms. Johnson. Thank you for your arguments. And can't come down and greet you, but know that we appreciate you being here to help us on these cases. Thank you so much. Take care.
apologies. Thank you, man. You know, I do with this. I apologize, Your Honors. With please the court, Danny Howell for the appellants Martin Conway and the law firm of Pesner, Kawamoto, and Conway. Well, this is a Barton Doctrine case, which at the outset has some jurisdictional questions, as well as a pending motion to dismiss on standing grounds. Would say that with respect to the largest question, perhaps, which is we have an order from the district court that rejects a report and recommendation of the bankruptcy court with respect to two respects, Barton Doctrine violations and willful violations of the automatic stay by a former debtor in Chapter 11 and then 7 bankruptcy in a lawsuit, total of 3 suits, I guess, against their former Chapter 11 counsel, who was also subsequently in the Chapter 7 hired as special counsel by the Chapter 7 trustee under the statute that allows that. However, the district court, in its order, first said that the state court has to determine whether or not there was a statute of limitations issue, because in the court's view, the district court's view, the bankruptcy court was litigating the state court malpractice case by saying that it appeared to the bankruptcy court that the case would have was time barred on its face. And second, that the district court entered a discretionary abstention under the bankruptcy statute that allows for that, which is, again, Section 1334C1, with the notion that it was necessary for the state court to make a determination that would have some bearing on the Barton Doctrine.
Can we review the district court's decision to abstain?
And this is why I brought it up first. In our view, the notion of abstaining under the statute to a proceeding, and the word proceeding is used in both the permissive and mandatory abstention portions of the statute, a proceeding which essentially will be void ab initio because there is no jurisdiction for that proceeding. It doesn't hold water, although I will say right away, there's virtually no authority, and if this circuit chose to address it, it would be the First Circuit Court of Appeals to address the question in a Barton Doctrine case, with Barton Doctrine being jurisdictional exclusively to the bankruptcy court. Can a state court proceeding be the subject of abstention, which effectively leaves everyone out of court? The whole point of the Barton Doctrine is, if it applies, to never permit this type of proceeding to go forward. Yeah. If abstention is allowed, yes.
I found the district court opinion a little confusing, and maybe you did too. There seemed to be a ruling about the Barton Doctrine, but then the court seemed to abstain, saying, there are facts that need to be sorted out potentially in the state court about who was, in what capacity was Conway acting, right, as the attorney for the company or in service of the trustee, et cetera. And so out of kind of comedy, I'm going to defer to the state court to decide that as a kind of preliminary matter. And then, as you mentioned, the same thing with the statute of limitations, that I'm going to defer to the state court on that. And if that's what the district court did, if we get into the merits of the Barton Doctrine, aren't we reviewing the merits of the abstention decision?
You would necessarily, the court would necessarily have to determine that in this particular scenario, the abstention statute does not apply. That's a question of law. If I'm wrong, we're not here long with respect to that issue, but we are effectively out of court, because all anyone has to do when a lawyer hired by a trustee is sued by the former debtor is sue them for some breach of duty and challenge that particular, the jurisdictional issue should be the one that weighs out. But have an abstention order entered so that it's guaranteed that when the case in the state court is done, there's nothing left for the bankruptcy court to do or the U.S. District Court to do. To your first point, Your Honor, as far as what the district court did, this is a little bit watch what it did, not what it said. Because, yes, it did say at the outset that it was making a determination as to the Barton Doctrine, but then it said, well, no. This is the whole point of this is that the state court is the only court that's going to litigate the statute of limitations, and that was fundamentally wrong. Because that's not what the Barton Doctrine is. The bankruptcy court doesn't say we're going to figure out whether or not there's a malpractice case here. It says first, was this suit brought before there ever was a request to us, the bankruptcy court, for permission to do it against an officer of the court appointed by the court to assist in the only thing that was left to do at Chapter 7, which was to seek 3 collection cases, no other assets there. If that suit was brought before there was permission, it could be the most prima facie, well-pled case in the world, and it's void. And there's no further inquiry. If it's not the case, and that you can do this as the bankruptcy court did as an alternative, one of the factors is whether or not there's a prima facie case. And if there isn't, this is a jurisdictional determination. No court is ever going to determine the matter if the bankruptcy court says, prima facie, it looks like this case is barred to me. It doesn't seem like it is a case that will hold water. It's one of the factors I consider in my decision, assuming there was never a suit filed. In this case, there was a suit filed twice without ever asking the bankruptcy court for their permission. There was a trip to the bankruptcy court, and then a quick trip back with the notion that, well, maybe this isn't something we really want to ask about. The district court got it backwards. And again, in our particular instance, the Barton Doctrine determination has nothing to do with the state court determination, which, by the way, the state court subsequently, with the case restarting, it granted summary judgment on the statute of limitations. We're on the Court of Appeals. I don't know how long we'll be there. Ultimately, if this sort of question came up again with respect to the Court of Appeals actually reviewing it, my guess is the Supreme Court of Virginia would likely take cert on this issue because it has to do in part with fundamental issues of accrual. However,
sorry to interrupt you. Does that moot anything in front of us? I know there's still a sanctions argument, but is anything mooted in front of us since the proceedings in the state court have gone forward?
Well, no. Again, what's happened so far is something that at the end of the day is likely to be deemed to be void. We will spend years, as we've already spent 5 years, litigating this matter to no end, because at some point or another, when someone gets the chance to do it and make a determination, this case is about as clearly violative of the Barton Doctrine as anyone is ever going to see. And beyond that,
can we receive a submission about the state, what has happened in the state court since this was briefed?
I have not, and frankly, I was uncertain as to what we were.
Oh yeah, I'm not saying anyone's at fault for not doing it. I'm asking someone to please do it.
Oh, I'm sorry. Well, of course, I apologize for not understanding. First, I got scared.
Sure, I understand the panic instinct when you're on that side, because it may not be determinative of anything. But as I was thinking about this case, I know that this was set for November, and I was curious about what had been going on.
And of course, I had to mention it, but I believe it's absolutely appropriate to ask for and to receive a brief. It would point out, obviously, that we are, well, in addition to what has happened, that we're still at the start of what probably is a long road. The case below on summary judgment turned, as did the issue of the violation of the automatic stay in the district court, on what constitutes accrual of the cause of action against a lawyer for malpractice. In both courts, the defining case is Shipman versus Kruk, which will have its 20th anniversary next year, and is the lead case in Virginia on this context, and it arises in bankruptcy, in which said, we start the clock when there's the slightest damage or whether it's an irreparable legal injury. In that case, filing a Chapter 7 meant the loss of a revocable trust. The debtor had the power, it transferred permanently to the trustee. There wasn't any damage for quite a while, except payment of a filing fee. In this case, there was extensive allegation of, in the Chapter 11 proceeding, that the attorney failed to properly fight lift stays, failed to get a plan approved, and ultimately the case was converted on the motion of the U.S. trustee, and when that happened, the only assets of this estate transferred in control from the debtor in possession to the trustee permanently. In fact, the debtor even lost the legal right to object to a settlement because it was a no-assets case otherwise. Under Shipman versus Clark, clearly there was accrual, and district court was wrong about that, saying that there wasn't enough fact to determine accrual. Accrual isn't that big a deal in Virginia in terms of figuring it out. Now, we said if in fact the statute with respect to abstention, discretionary abstention, is a hurdle that the court determines we don't overcome, that this really is an issue collateral to the underlying determination of malpractice, and one in which the litigants are effectively out of court if the case is not addressing this. And that has in particular application in the context of Barton, because again, the primary purpose of Barton is to make sure that trustees and the officials who are appointed to work for them don't spend 5 years defending a state court claim that should be barred under the common law of the Barton Doctrine. Most trustees are sole practitioners, those small firms, and they provide a service. They don't just make money. And one of the ways they do it is that they're not going to be dragged through court. This is a particularly egregious case, but that's not what determines things here. What is in fact at issue is, first of all, can we proceed because of the notion of this particular type of case fitting into that very narrow window of collateral order doctrine. And it's a square peg in a round hole for everybody who comes up and argues that before the court. But in this case, I do think it fits. And then ultimately, whether the court accepts the notion, there was an injunction entered by the bankruptcy court against further continued litigation of the state court, which injunction was lifted by the district court, and a refusal to enter an injunction permanently. And so we do have an appeal also with respect to that issue. And by the way, that's not something somebody threw in. The only reason that Martin Conway and his firm sought to reopen the bankruptcy case was because they'd been sued 3 times over the same facts over and over again and brought back into bankruptcy court from time to time. And there was not going to be an end to it, as sometimes there isn't. People in a divorce, people in bankruptcy, seldom happy with the outcome and difficult to let go of disappointed expectations. And this is a case like that. But that's what the Barton Doctrine is about. The bankruptcy court didn't just determine that the Barton Doctrine applied. It had actually done that a long time ago. It determined that there had been egregious filings after it had said, this can't be done, this is not permitted, and that there was a clear violation of the automatic stay, and that it was time for one of the very rare instances when any court ever does something like this, and join further litigation, not only by the party, but by their counsel, so that this stops. The district court had a view of this that was skewed based on, I think, a fundamental misunderstanding of how the Barton Doctrine works, although confusing to me, because just 2 years earlier, in almost the same set of scenarios with respect to the legal issues and the Barton Doctrine and the statute of limitations prima facie issue, the exact same court got it right down the road, and understood in that opinion, which we've discussed extensively in our briefs, that when the statute of limitations is discussed, it's only discussed by virtue of wanting to know whether or not it looks like there's a prima facie case. That opinion also said that when the suit is filed before permission is obtained, then that suit is without jurisdiction, even if, had permission been asked, it would have been granted, because it's too late. There is no redo under the common law of the Barton Doctrine, and that's a uniform law with respect to how that's applied across the country. In this case, the failure to do that wasn't just, well, all right, this was an omission. It was part of a pattern. And that pattern was serious enough for the bankruptcy court to do what it did. Now, by the way, the bankruptcy court said, this is a court proceeding. And indeed, it's hard to imagine how it isn't, because all he had to do, and the only thing Mr. Conway did, had to do with administration of the estate's assets. He was only hired basically to sell the assets by virtue of suing people and settling. That's all that anybody ever did here. There was nothing left to do. But in this particular instance, the level of egregious activity.
Doesn't our
Yes.
circuit give immunity to trustees when they're acting pursuant to a court order or within the scope of their authority? We have an immunity doctrine that's separate from Barton, right?
They do, and it is often something that that is adjudicated, although primarily, again, immunity has certain aspects that may or may not be a square peg for this particular case. But at any rate, the Barton Doctrine is simply, well, it is regarded in a certain way with a particular understanding that it is a primary job of the bankruptcy court. If the bankruptcy court is appointing trustees and is appointing court officers to assist them, professionals to assist them, the bankruptcy court is responsible to make sure that things don't happen that are just absolutely wrong, contrary to law, and harmful to the whole purpose of what the bankruptcy court's trying to do in allowing either estates to be reorganized, or allow the assets to be sold, and to allow people to get on with their lives. This can't happen.
And there's an argument to be made, right, that's the bankruptcy court, the reason it has this doctrine is because of the res, right, because of the estate, but that once the bankruptcy is closed, then maybe the Barton Doctrine shouldn't continue to apply. At least one
Yes.
court has said that, right?
Yes, and consistently, the answer from courts across the country has been that the mere fact that the case is closed doesn't change the need to protect the trustee and the court-appointed professionals.
But maybe that's
and also,
where,
by the way,
maybe that's where immunity comes in?
well, I think what operates is there is, in fact, still an estate that is being administered if someone's out there about to recover $2 million. This, as the joint appendix document reflects, after this case was fully administered, there were about $1.7 million in allowed claims that weren't going to be paid. The issue of what happens with respect to that particular type of lawsuit goes directly to what the bankruptcy court's doing, I think. And the inability, by having an order that basically says, no, the bankruptcy court can't adjudicate state law claims, the inability to really do its job under that circumstance is significant in terms of its impact down the road. By the way, this court's opinion in McDaniel versus Blunt, with respect to attorneys being encompassed in the protection of the Barton Doctrine, who are especially special counsel, obviously, who have this limited function under the statute, the effect of the abstention, that's going to obviate the impact of that case, at least as far as lawyers or other professionals are concerned. And in fact, that's already sort of the talk of the bar to some extent. That particular opinion was the first time the Fourth Circuit had spoken on that issue, although it joined the other circuits that had addressed it and agreeing with it. Nevertheless, it provided clear, important protection. And that's not going to happen if abstention is allowed, and if we don't have at least a notion that even if we can't address abstention, we can address this as a collateral issue. There's nothing in the state court, and it'll be clear from the report that we submit, Your Honor, there's nothing in the state court that addresses Barton. Now, in theory, a state court can address it, but the state court's not in the position of really being aware, having sufficient facts, having sufficient prior experience of administering federal common law under the Barton Doctrine. And so generally it doesn't happen. That's why there's a requirement to come back to the bankruptcy court before a suit is filed. And when that requirement's violated not once but twice, and then the pleading is amended to do as things the bankruptcy court was warning against, the bankruptcy court is the court that's equipped to understand how to protect the interest of everyone who appears before it. And that's why this doctrine is so important. The fact that we have one opinion so different from what happened 2 years ago with the same court suggests that there's some serious need for clarity that would be beneficial to the court system in the entire Fourth Circuit should this court deem that it can address this case and then address the merits. And I only reserve 2 minutes, so I still have time left. I'm sorry. Not used to that.
Counsel, when the numbers are going up, that's how much time you're over.
Oh, my gosh. I apologize. I get my glasses checked. Thank you very much for your attention.
Thank you. Thank you. Mr. Lopata?
May it please the court, John Lopato for the, excuse me, Your Honors, for the appellee Smith Development, Inc., and with me is the president of the corporation, Mr. M. Kevin Smith. Your Honors, in addition to jurisdictional problems about appealing an abstention ruling, there are other jurisdictional problems here before the court to even hear this case. We filed a motion to dismiss that said that the reopening of the case by Conway Pesner, reopening of the bankruptcy case, excuse me, in January 2019 was not in accordance with the reopening standards under 11 U.S. Code 350. That says a case can be reopened by a debtor, creditor, or party in interest. Now, the party in interest has to have standing, but also has to have subject matter. And the most important subject matter reason to reopen a closed bankruptcy case is to gather more money, more assets to pay off creditors. Their petition is in page 451 of the appendix, petition to reopen. It has nothing about that. Also, professionals.
What about the party and interest requirement suggests that it's jurisdictional rather than it's just a requirement for proceeding to reopen?
Well, Your Honor, we also, in our motion to dismiss, stated that lawyers sometimes can be a party in interest to reopen, but only if they are doing so to protect their fee. We didn't challenge the fee they took.
Right, but isn't this an argument about whether they fall within the class of people who can bring this claim, whether they qualify to take this action? Why does it have to do with the power of the court? Why is it jurisdictional?
Because, and we cited cases where courts have not permitted reopening because they haven't pleaded that they haven't put in their petition to reopen that we're doing so to gather more money for the creditors. And they didn't do that at all here. End of story.
Again, that might mean that they shouldn't be allowed to proceed, but why is it jurisdictional? Why does it have to do with our authority to hear the case?
Well, it was the bankruptcy court who made the mistake. We opposed the reopening and they proceeded. The bankruptcy court then made a report and recommendation to the U.S. District Court that the U.S. District Court rejected. But I'm going back earlier and saying the bankruptcy court was incorrect to grant the petition to reopen. Remember, the petition to reopen came 4 months after we had.
Are you saying it was incorrect to grant the petition or that it lacked the power to decide?
Both, Your Honor.
And where is it in the statute or the rules that we see that the court lacked the power?
We cited those cases in our, I don't know if we worded it that way, Judge, to be honest. We cited those cases in our motion to dismiss that said that if you don't satisfy the requirements of reopening the case to get more money for the creditors, the petition to reopen should not be granted.
Well, one thing, it seems to suggest that it might be addressing Judge Rushing's question is that here, it tends to seem to be jurisdictional because it's not only the personal standing, but actually the question of the subject matter itself. It's to protect certain interests. And what you're saying is that they don't allege an interest that the bankruptcy would have any basis to protect once it's closed.
That was exactly the thrust of our motion to dismiss. They weren't challenging, weren't seeking to protect their fee. They can keep that fee. Now, the fee they took below in the bankruptcy court was a disgrace to the Virginia bar and a disgrace to the bankruptcy bar. They cheated and deceived and misled this corporation who was their original client. And then we cited the letter they sent to him in November 2010 and said, you better cooperate with the trustee, even though we helped you, we're representing the trustee. But they never explained to him that when they're appointed to represent the trustee under 11 U.S. Code 327E, that they abandon all their obligations to their original client, the debtor.
So maybe it's like prudential standing, it's like statutory standing. You don't dispute that they have Article 3 standing, right? That they are claiming an injury that could be corrected by a court order.
Well, Your Honor, we're here on the district court's rejection of the report and recommendation. I'm just saying that.
Yeah, but you see my sticking point is you say we should dismiss for lack of jurisdiction. And the Supreme Court has told us, a lot lately that we use the word jurisdiction too much to mean things that aren't actually about the court's power to decide. It's not that the bankruptcy court acted without authority, but rather that the bankruptcy court, you think, got it wrong in assessing who this was meant to cover, who was meant to be allowed to reopen.
Yes.
And that is maybe a substantive, a merits argument, but it's not an argument that the court lacked jurisdiction.
I believe we captured enough of that to meet the court's concern in our motion to dismiss, Your Honor. And the briefing went beyond that. But I was saying that, remember, this petition for reopen came months after we had survived the first motion to dismiss in state court on our legal malpractice action. And that was another reason it should not have been granted. Now, they cite only a few cases on reopening a case. The Brooks case they cite from the Eastern District of Virginia was not a Barton Doctrine case, and that one's where the debtor moved to reopen. Well, the debtor's right in the statute. He can do so. But the court said, we're not abandoning the reason you're reopening this. It was a tax refund, because that might go to creditors that can participate in this money. What my brother Howell said is absolutely false. This bankruptcy case in an in-rem court is long closed. The statute of limitations of the creditors have run. Any money we get from the Conway lawyers will go directly to this corporation. And the district court judge so held. They also cite a case from New Jersey, the Honig case, but that was reopened because the debtor the debtor's lawyer was accused of committing fraud on the bankruptcy court. They said, we'll abstain, but we're not going to issue an injunction against the state court matter. Your Honor, on the abstention doctrine itself, the district court cited two important decisions from this circuit that the Conway lawyers do not respond to at all in their opening brief or reply brief. The first was the Trustagard case, where there was a declaratory judgment filed in federal court on a simple automobile accident case over insurance coverage, and this court said that it's not appropriate to invoke declaratory judgment or get involved in this matter at this time because we need the state court record to be developed and decided. The other case about injunctions issued against the state court, which is what this bankruptcy judge did, is the A.H. Robbins case from this court, a Dalkin Shield case, where this court laid out an elaborate test for issuing an injunction against the state court, knowing how serious that was. And it said there were state court actions by insurance companies on these Dalkin Shield actions that would directly affect the amount of money available in the bankruptcy court to pay the Dalkin Shield claimants. And the court said, yes, in that case, we will grant an injunction. That elaborate test can't nearly be met by them. Now, let me talk about the Barton Doctrine and how it's
I mean,
overstated.
Isn't your best abstention argument not an argument on the merits, but an argument that we lack jurisdiction to review a grant of abstention?
I would agree with that, Your Honor. And my adversary I don't think, answered the court's questions. This is an area that the court should decline to entertain jurisdiction over this appeal from the abstention ruling. Because, and I'll get to his scare tactics about being out of court and Barton Doctrine and what the bankruptcy bar is talking about right now. The bankruptcy doctrine was not violated by the complaint of Smith Development, Inc., because we were not suing the trustee directly. We were suing the debtor's attorney for actions he took that directly damaged the debtor. The famous case of McDaniel v. Blust from this court calls out for the question, who is suing who is suing whom for what? In that case, the trustee had a law firm. He hired one of his own lawyers in his law firm. They had not represented the debtor. The trustee hired a lawyer from his own law firm, and they sued officers of the debtor corporation for looting the company, trying to get money back that they could distribute to creditors of the debtor corporation. The officers of the debtor corporation sued the lawyer the trustee hired in state court and said, you used false income tax returns to proceed against us, and it was removed to federal court. This court upheld application of the Barton Doctrine because it said the lawyer was working for the trustee to gather more money to pay creditors. The lawyer was not subject to a conflict of interest complaint as we have here. The lawyer and the Conway lawyers, by contrary, they helped prepare spreadsheets and damages in these adversary actions for their client, the debtor corporation, showing $2 million worth of damages. Then they secretly...
Do you agree, Mr. Howell, that a state court can apply the Barton Doctrine, that if someone brings it up in a state court proceeding, then the state court can assess whether the doctrine prevents it from
only the
exercising?
bankruptcy court can issue the Barton Doctrine. And the state court,
Why is that?
Well, because the Barton Doctrine originated as a protection of trustees who would be subject to lawsuits, usually by creditors, who claim they're being overreached, or people, creditors or people that owe the debtor money. That's how it originated.
Right, but what's to prevent a state court, someone arguing at the state court, this proceeding is prohibited because of the Barton Doctrine?
The state court here had no occasion to rule on that because they weren't, they've been enjoined by the bankruptcy court from proceeding because of the Barton Doctrine, but the district court lifted that injunction.
Yeah, I'm just asking as a legal matter, not, regardless of kind of what happened in this case, I'm just trying to sort out, is this a doctrine that's available in state court also?
The defendant could only invoke it the way they've tried to here. The defendant attorney, if he sued, could only invoke it the way they tried to do here. Get relief from the bankruptcy court or ask the United States trustee, who now appoints the Chapter 7 trustees, to help him. But let me talk about his sympathetic story about the small law firm serving as trustees. The Barton Doctrine has always been stated that we want to encourage people serving as trustees. That's not at play at all here. This law firm had already entered the fray. They were paid money by the debtor corporation to file the petition first for Chapter 11, and then they continued to represent them after the conversion of Chapter 7. We lay out in our brief how they, in another case where they were representing him individually, they said, oh, that could be a conflict of interest. We'll get an order of withdrawal and substitution, get another lawyer in. They did that. They never did that upon the conversion of this case to Chapter 7. They never sat down with the client. They said, under Chapter 7, we've now been hired by the trustee to finish up these 3 big adversary actions, and we're going to be primarily answering to the Chapter 7 trustee and subordinating your interests. Why don't you get a new lawyer? They never did that. And those are the arguments we used to persuade the state court judge to sustain the cause of action in their first motion to dismiss. Now,
And I'll just reiterate, since I mentioned it before, for both sides, if you would be willing to file a 28J letter, just a short letter within the next couple of days, summarizing for us the current status of the state court proceedings, I would find that helpful.
we conferred before the argument, Your Honor, and realized we were remiss in not doing that. There's an appeal pending on whether a 5-year statute of limitations applies to a written contract they had with Smith Development, or a shorter statute of limitations applies whether there's just an oral contract after the conversion to Chapter 7. That's the issue, and we're confident we're going to prevail on that, but we'll report it to the court. It's pending at the Virginia Court of Appeals. Under the new code in Virginia, we now, hallelujah, get an automatic right to appeal a state court ruling to a higher court. It used to be by just petition for writ. But let me cite to another important element of the abstention and the deference to state court here in the comedy that Judge O'Grady discussed in his district court decision. Virginia Code 54.1-3906 says that, quote, every attorney shall be liable to his client for any damage sustained by the client through the neglect of his duty as such attorney, end of quote. That's very rare. Few, if any, states have that. And that's a valid element that must be deferred to under comedy and under the abstention doctrine, and also under the Stern v. Marshall case from 2011 from the U.S. Supreme Court. That case limited the ability of the bankruptcy courts to intrude upon state court matters, even if they're core, even if they're going to get some money for the estate. But here they're not core. They're not going to get any money for the estate. And the district court properly recognized that. And the district court also acknowledged that the Smith Development as debtor never consented to having the legal malpractice case tried in the bankruptcy court. It belongs in the state court. Your Honor, unless your honors have any questions, I urge you to affirm the district court on all its elements. They have jurisdictional problems on whether an abstention can be appealed, but they also have procedural problems on whether the petition for reopening was even valid when it was granted in January 2019 by the bankruptcy court, because the petition to reopen lacked any of the required elements or components to have a bankruptcy case reopened. It did not seek to get more money for the creditors, for the estate, and it did not seek to protect a professional's fee. Thank you.
Thank you, Mr. Lopato. Mr. Howell, you have some time reserved.
I'd like to answer Judge Rushing's question with respect to the state court jurisdiction to entertain a Barton Doctrine challenge. I don't know whether it helps me or not, but I'm not going to pass on at least the opportunity to share what the law is, because I know what it is. The state court has full authority to do that. Similarly, the district court, the U.S. District Court, if a case is brought to it that should have gone first to the bankruptcy court, numerous district courts have held we don't have jurisdiction over this. Bankruptcy court is the only court that makes the determination about whether or not it's violated, but the state court can say, in our view, what's in front of us looks like it's violative and we're not going to do it. And then they can go to the bankruptcy court. The problem is they've already filed. See, again, if they had such a slam dunk malpractice case, you'd think they would have asked the bankruptcy court for permission before they filed it instead of afterward. That's what they did.
I appreciate that. Thank you.
I'm sorry.
Thank you for clarifying the legal question. I appreciate it.
And
I commend you for
better or
raising-
worse.
You pointed out abstention in your brief too, which again, you did it because it was the law, even though it may not benefit you, and I wanted to commend you for that. I thought it was, your candor with the court was commendable.
Old enough now to try to get it right, regardless. And by the way, I think it might be helpful if in a short letter with regard to what happened, the circuit court did issue a letter of opinion, and it did also have a ruling from the bench, and it might be useful to provide that.
I think it's fine to attach that to the 28J if the other judges are okay.
You think that's appropriate, a 28J letter?
Your Honor, no, as you asked the question, I know that I was wrong before you finished the question.
Right, okay,
I apologize, Your Honor.
okay.
So I've been, I know that, 10 seconds, I've been on the losing end of trust guard arguments before this court, but trust guard didn't have anything to do with an unknown area of the law. The court for the bankruptcy opinion we cited from the Sixth Circuit said the Sixth Circuit has not passed on the question of whether or not abstention is permissive, is going to be allowed in a Barton Doctrine case. Said it for a reason, hasn't been addressed by any circuit court. Thank you very much, Your Honors, if there are no further questions.
Thank you both, counsel, for your arguments. Very complicated case, and we appreciate so much your coming, helping us with this. And we'd love to come down and greet you as we normally do in our tradition, but we can't. But know very much that we appreciate your being here, and we wish you well, and be safe. Thank you so much.
Thank you, Your Honor.
We'll proceed to our last case for the morning.
Yes. Good morning, Your Honors. My name is Gasper J. Bono, and I'm appearing on behalf of Appellant Woody Industrial Company Limited. In this appeal, there are two fundamental questions for this court. One, what is the plain meaning of paragraph 6, in particular paragraph 6B? When that paragraph is understood, it is clear there has been no breach by Woody. And the second issue before this court is, did Wong, the appellee, meet its heavy burden for entry of an injunction? And the record is clear that Wong did not. Under Virginia law, the interpretation of a settlement agreement draws on standard contract principles and is subject to de novo review. The Supreme Court of Virginia has explained the search for this plain meaning does not myopically focus on a word here or a phrase there. Instead, it looks at a word in the context of a sentence in the context of a paragraph, and a paragraph in the context of the entire agreement. The plain meaning of a word depends not merely on semantics and syntax, but also on the holistic context of the word within the instrument. Now, Wong is asking this court to look at the phrase in 6B with blinders on. But as the Virginia Supreme Court has made clear, each paragraph and the entire agreement needs to be looked at in order to understand what does paragraph 6B mean. Now, if you look at each paragraph of this settlement agreement, it provides separate and distinct obligations and restrictions, and it distinguishes very clearly between visible content on websites and platforms on the internet and what is not visible on these platforms. For example, paragraph 2B addresses trademark terms, and it relates to the parties' respective obligations under trademark use. Paragraph 3 talks about manufacturing and says where you can manufacture your branded products. Paragraph 4 specifically addresses advertising and promotional materials, and it says it relates to those materials and prohibits each party from engaging in the use of other parties' marks on websites or in other advertising materials. Paragraph 5 addresses websites and relates to website contents, and it prohibits each party from using the other's website contacts or content, product descriptions, photos, or images on a landing page. Now, paragraph 6, which we're talking about here, is captioned AdWords, and it relates to words for what is known as targeted advertising on search engines or shopping sites, or similar terms or keywords on social media platforms. And this is clear when you examine the platforms that we're talking about here, because paragraph 6B was not written in a vacuum or with blinders on. It was written with an understanding of what the platforms and the social media platforms provides, and it was written as part of the entire agreement. And with the knowledge of these existing platforms, shopping sites, social media sites, and what each of those media provided in terms of targeted advertising, such as the use of keywords or AdWords that operate to drive users to certain pages on their respective platforms. And we outlined this in detail in our opening brief at pages 19 and 24. And it's very
Now, you're
important.
appealing, you got two appeals here, right?
Well, we filed 2 notices of appeal if you're one
They've
prior to
been
judgment.
consolidated.
Yes, correct.
And you got 2 orders.
Correct.
Do you have any findings of fact or conclusions of law from the district court?
No, the district court violated.
No, you don't have any findings of fact or conclusions of law from the district court.
No, Your Honor.
Are you appealing a specific performance order or an injunction? Or both?
Your Honor, as we argued below and as we've argued on this appeal, despite the fact that the district court calls this a specific performance order, it clearly is injunctive in nature. I respectfully
So you
submit.
say you're appealing an injunction?
Yes,
Is
yes,
that
Your
what
Honor.
you say?
Yes, Your Honor. And the order as it exists.
You're appealing an injunction, in which order? Or both orders?
Both of his orders, the April
You're
20.
appealing 2 different orders, and you say both of them are injunctions?
The second one was, he termed his second order not an injunction, but because he endorsed the first order, it is an injunction. Yes, Your Honor, because it orders enumerated steps.
He said it's the first order that you say is an injunction. The judge said it's a specific performance order.
And it was erroneous for him to say that
But you
because,
say, and you're claiming on appeal that that's erroneous.
yes, Your
correct?
Honor, yes.
And you argued to the district court that it was an injunction.
Yes, I
versus an injunction.
personally argued that to him,
And-
correct.
And did you argue to the district court that he had to make findings of fact and conclusions of law?
Yes, Your Honor,
Pursuant to
specifically.
Rule 52?
And 65, yes, Your Honor.
Well, 65 pulls through 52
Yes, Your Honor.
for an interlocutory injunction, and granting or refusing an interlocutory injunction, the court must similarly state the findings and conclusions that support its action, referring back to that. But anyway,
Yes, Your Honor.
so you say it's an injunction. How are we supposed to be able to review it? We don't have any findings or conclusions of law.
Well, I
It's not
understand.
explained.
I understand that the district court's failure to comply with Rules 52 and 65 puts this court at a disadvantage because you're left without, as one of your earlier cases, the why. Why did the district court draw his conclusion? Because he didn't do the evaluation and make the findings it should have, and that's
You all had an oral argument in the district court, didn't you?
That's correct, yes.
1 or 2?
2,
2 oral arguments in the district court.
yes. And in both arguments, we asked for that, we made it clear that he was required to make findings of fact and conclusions of law.
And
We also,
and you say on appeal he hadn't made them.
That's correct, Your Honor,
So
yes.
do you want us to remand it to have them made then?
Well, Your Honor,
But you're saying this is an injunction, it's not a specific performance order. So what do you want us to do? You want us to say it's an injunction without the required findings and conclusions required by the rule and remand it for compliance with the rule?
Your Honor, that's our...
Is that what you want, or you want us to figure it all out ourselves?
Well, I understand the second argument is also something I believe that you're required to do on the second issue as to whether an injunction...
We weren't required to do it, the district court was required to do
No,
it. Under the rule is what you say.
Yes, Your Honor. So let me be clear, there's two issues here. There's the issue of breach, and there's the issue of injunction. And
the stay order, and you came up here and asked for a stay, and you got a stay both times.
that's correct, Your
So
Honor.
the order is not, whether ever it is,
It stayed.
it's not effective on you.
That's correct, Your Honor.
So
And-
we'll put a stop to it.
Yeah, and if this court decides to simply remand this case without making a determination on breach, which I would like to argue that you should also make a determination that there was no breach, but if you do that, I would respectfully request that this court...
How can we make a determination on the breach when there have been no explanation of the so-called breach?
Be-
Or no ruling on
Right.
it? It's been explained.
So, Your Honor, let me finish my first statement, and I'll answer your question. If you do remand, I would respectfully request that this court continue the stay until the district court makes its second determination, and we see whether another appeal is required, in all fairness.
You
But
recognize I'm the only, I don't know if you do or not, I was on both of the stay motions.
I know that very well, Your Honor.
And
Yes.
and there were 4 other judges that were involved on the difference. I'm the only common denominator.
I appreciate that, Your Honor. When I saw the list this
Stay
morning.
both times. Did you know that?
I'm sorry, Your Honor.
I voted against the stay both times.
I saw your dissenting comment,
Do you
Your
know
Honor.
why I didn't vote against the
I believe it was a procedural question on Rules
procedural
8A.
default on your part that you didn't move in the district court for a stay from the district court? Either time. You came up here.
Well, Your Honor,
You came up here, you didn't comply with the rules of the court.
I understand that was your opinion. I was not involved at that time, so I can't.
That was my problem. I didn't ever reach the merits or consider your merits of your stay motion because you failed to go back and ask the district judge for a stay, which is the rule requires you to do it, or Rule 8, I think it is.
I appreciate that was Your Honor's opinion at that time.
That was my view, why
And-
of the stay motion. But now it's up here and you still don't have the findings if it's an injunction.
Yes, Your Honor, but even if it's not an injunction, this court's opinion in Hensley, where there's a dispute over a settlement.
If it's not an injunction, it needs to be explained. Is that what you're saying?
I'm sorry, Your Honor?
No, if it's not an injunction, it still needs to be
Under
explained.
the Hensley ruling, this court ruled that the court was still required where there was disputed provision of a settlement agreement to have an evidentiary hearing and to make findings of fact and conclusions of law so that this court could have the opportunity of a full record to review that. Yes, that's
Can I
correct.
ask about that? It seems to me the case is about enforcing a settlement agreement. They envision an evidentiary hearing and findings of fact because the parties don't agree on what the settlement agreement is, right? There's a factual dispute about, did we agree to X or did we agree to Y? Or is there even an agreement? Here, there's no dispute that an agreement exists. There's no dispute about what it says. The dispute is about interpretation, right? Legal interpretation of the words of the agreement. Were there any disputed material facts? My understanding from the briefing was that no one disputed the facts are the facts, and the question is, do those facts violate this provision? But am I wrong about that? Were there material disputed facts?
The dispute is what that term, that phrase in paragraph 6B means. That is a material dispute of great magnitude to
Right.
my client.
And that's a legal question, right? It's a question of contract interpretation. You just told me that contract interpretation principles apply.
Yes, and that's why I separated out the two issues of breach and injunction. And I agree with Judge King. If this court were to reach the injunction question, meaning you're going to rule that there was a breach, which I respectfully submit you should not do on this record, but if you get to an injunction, I respectfully submit you cannot, that injunction should be reversed because the findings were not made.
But what are the findings? What findings of fact need to be made if there were no factual disputes?
The judge didn't make any findings. What the parties negotiated, what that provision means, what the parties understood it to mean at the time of.
He has a detailed order saying what you can and can't do, and that makes pretty clear
He
what.
doesn't say what we can do. The order says we have to do all these things, and those provisions in that order were not in the agreement. They're not in the agreement. He didn't say comply with this term of the agreement that says this. The order doesn't say this. It was a verbatim order submitted by the other side, and Judge Hilton just signed it.
My question is just, should I read the order to be his interpretation of the agreement, right? If the question is, what does paragraph 6B mean? The judge issues a ruling saying, you're in violation because you're not doing X, Y, and Z. You need to do X, Y, and Z. Then we understand that that's his interpretation of the paragraph?
Quite frankly, it's not clear because he didn't make any findings, but the order doesn't say, I find this, I find it. He just says, you need to do this. And the assumption there is that he has reached some interpretation of 6B, which he made, and therefore he ordered my party to do these things, which are not terms of the agreement. And the reason is that paragraph 6B talks about the concept of targeted advertising and AdWords when you put it in the context of the settlement agreement, and you understand what Google and
You disagree with his interpretation, right? I get that. I'm not sure. You're saying I can't glean from his order what his interpretation was, and therefore I need to send it back and ask him, what did you think this paragraph meant?
Well, yes, because we are all assuming the assumption is that he understood that he was interpreting paragraph 6B to say, you can't put a chair with your trademark on a web page on Facebook with your own product if it's somehow, and you do that in the United States where you have a right to do it, and now if that is accessible, can be seen by somebody searching the internet in the United Kingdom, that's a violation when paragraph 6B has nothing whatsoever to do with visible content. And if you understand the agreement and you understand what the search engines and the shopping sites say, they have this targeted advertising program that use terms and keywords. And the person that has that page, that video, you go into those sites and you preset certain directed advertising terms. And so that when a user, you and me, go on the internet and you search, you put in things, how does it get to the video? Because you pre-programmed this targeted advertising with these terms. And if you understand that from those websites and you read this contract, it says terms with or without other words that use. It draws the language right from those platforms. And it makes sense because the visible content prohibitions of the agreement are in other sections of the contract very clearly. Paragraph 6B has nothing to do with visible content, and Judge Hilton assumed it did because he did not understand what AdWords and these terms were. He viewed it as advertising, which you would think in the old world, the non-internet world, you would have something visible. This is not visible content at all, and he misunderstood the agreement. And if he had made the findings, I submit, and actually got into the understanding of the agreement, I think this would have been seen. But I think on this record, as we've submitted on the breach, on this record, to understand the plain meaning of 6B, this court can rule that the plain meaning of that is targeted advertising on these platforms with this non-visible targeted advertising, which Long does not allege that we violate.
I don't want to take over get into your rebuttal time here, but This evidence you're talking about how the AdWords are used and the invisible content, did you present evidence along these lines? Your friend on the other side says no parole evidence was presented in the district court.
In his declarations, Your Honor, he put in the web page links in his declaration in the court below. He opened the door, and that evidence was put in there in the district court at that time. And, Your Honor, we believe it's appropriate to present that to this court, either for that reason, a rebuttal, for explanation, for attorney argument, and if necessary, judicial notice.
I'm asking, did you present it to the district court? Not is it appropriate
We
to
argued
us?
it was targeted advertising.
Did you give the court the evidence?
The evidence was cited in his
Did you all ask the
declaration.
district court for an evidentiary hearing?
Yes, Your Honor.
You asked for an evidentiary hearing
Yes, Your
to
Honor.
call witnesses and to present evidence?
We did below, yes, we said.
And you presented evidence?
No, he didn't. He ruled that was not
He
necessary.
ruled it was not necessary.
Not
but
necessary.
You asked for the evidentiary hearing. Did
And-
they ask for an evidentiary hearing as
No,
well?
no, he
Pardon?
did not. I don't believe they did.
They object to your evidentiary hearing?
I don't know if it was an
But
objection.
you were denied an evidentiary hearing.
That's correct.
All right.
Thank you, Your Honor. So I'll reserve the rest of my time for rebuttal.
Thank you, Mr. Bono. Mr. Riley?
May it please the court, Craig Riley here for the appellees, that's Wong and GTOR. None of the factual contentions that are the basis for the appellate argument now made by Woody were actually presented to the district court. Just to answer that one last question, not a single bit of evidence about AdWords and keywords was presented by Woody below. When asked whether they had any concerns about the form of the order that the judge was about to enter, Woody was asked that question below and said, "No, Your Honor, we don't." Woody's contract construction arguments that were the basis for the arguments made today, none of them were made below, even though now they say this is the obvious plain meaning of the contract. Not a single one of those arguments was made below. As the court knows, this is a concurrent use agreement to resolve a trademark dispute. The parties agreed they would continue to use their own marks subject to certain restrictions. Neither party has what they claim they have, which is the unfettered right to use whatever trademark they want, wherever they want, as their global brand. Both sides agreed to specific limitations. He says this paragraph 6 is just about AdWords and keywords. That is not what they argued below. Below, they presented this as evidence from their only witness, which is Mr. Wu Peng, who submitted a detailed declaration. There are no other witnesses to call other than Mr. Wong, my client, and Mr. Wu Peng, their client. He says...
So there were two witnesses that could have been called.
Who could have been called. And to answer your question...
And did they ask to call either one? He said he asked for an evidentiary hearing.
They both parties submitted extensive
You didn't
declarations.
answer my question.
Your Honor, they did ask for they said that live testimony should be received. But to go further to answer the second part of your question is, they proffered no additional witness or evidence they would have presented had they been given the opportunity to present a live testimony. And under Civil Rule 43C, the court is allowed to decide a case on affidavits if the record is clear. And in an evidentiary
You all
hearing...
agreed to let it be decided on the affidavit?
Yes.
Was there a stipulation then? Was there a stipulation of the parties as to the facts or that it could be decided on affidavits?
Yes. As we pointed out, both below and again...
And what was the judge supposed to do with conflicts in the affidavit?
There weren't any.
There were no conflicts.
There were no
Was there a
conflicts.
stipulation, there were no conflicts.
There was not a stipulation but there were no conflicts.
How are we supposed to know all that when there are no recitation of the facts supporting the ruling?
Understood, Your Honor. And I've been appearing before Judge Hilton as long as he's been on the bench, and no one would ever accuse him of prolixity. But his findings, which are stated on the record, are sufficient.
Well. He's a friend of mine.
Yeah, and of mine as well, Your Honor.
I'm just stating, I'm dealing with the situation we have before us.
Yeah. And what Judge Hilton said at the conclusion of the first oral argument was this: all right, well, I believe the matter can be resolved on the affidavits that have been presented here and on the argument.
Resolved on the affidavits, I remember that, which indicates to me he was going to make findings. That the affidavits are going to be looked at and make findings. And there are disputes there. I guess that it's implied stipulation the judge is going to make the findings. He says he says they asked to put on evidence and it was turned down. The judge didn't need it.
Correct. But they made no proffer of what live testimony they would have put
Anybody ask
on.
him for a proffer?
I'm sorry?
Did anyone ask him for a proffer?
Did the judge ask them for a proffer?
Anyone?
No. But they didn't offer it. They clamored for a live testimony, but then and still have not identified another witness or any testimony that they would have presented, nor have they identified either below or here any evidence that they were unable to present by affidavit below. What they did present...
How are we supposed to know what the facts are? We're supposed to look at the affidavits? But you need to understand that courts of appeals are generally, almost always, maybe always, courts of review, not of first view. Another court has to make the first view, and particularly with respect to findings of fact and conclusions of law that deal with those facts.
I agree, Your Honor, and we don't
And
take...
we don't have any here.
What we do have, and again, this is...
We have an order that you wrote.
Correct?
I know.
And we have the judge's remarks...
You wrote it and he signed it.
And we have the judge's remarks...
Is that right, counsel? Judge King's
Yes,
question?
it was prepared, it was a form of order that we prepared and submitted to the court.
Verbatim?
Yes.
Verbatim, it was signed by the court.
And before he signed it, he asked Rudy if they had any problems with the order, and they said in the record, they said no.
Other than the obvious, they object to it, and that's why they
Well,
appeal.
they said they objected to the substantive ruling, but they had no concerns about the form of order. They were given that opportunity and did not...
And they immediately came up here with an appeal and moved for a stay.
Correct.
That's indicating they didn't like it much.
Right.
That they asked for a stay, and then you got another written document from the judge explaining it some and saying it was not an injunction, it was a specific performance directive.
Correct.
Did you write that one too?
That order, no, I did not, Your Honor.
Okay.
But I did appear for those... I've been
I know.
part of this case all the way along.
Then it came back up on another
Correct.
appeal.
But at the first hearing, Judge Hilton went on to say, and again, under Rule 52A1, a court may make findings on the record transcript. He says, and it appears, it's clear to me that there is a violation of the language of 6B of this agreement, and you, Wong, are entitled to an order for the enforcement. He went on to say, I think I have found that we have ample evidence that your client, he was speaking to Woody's counsel, is using the terms that they're not supposed to be using, and my order should cover their activities and correct that situation. When it went back on remand, and he was asked to clarify whether this was an order of specific performance, he said yes, and when challenged by Mr. Bono at the hearing that it was really an injunction ordering him to do things way beyond, Judge Hilton said, my point was that the order I entered, I simply ordered you to comply with the settlement agreement. It is clear, and I think Judge Rushing was getting to this point, that if you look at both the order that was entered and his remarks at both hearings, it is clear he was entering an order of specific performance, limited to contract performance, and that his findings were sufficient to support this. Now, even if he had made detailed findings, we'd still be here. This court would still be asked to review the same record, factual record, to determine whether the judge's findings and conclusions are supported by the record. I respectfully submit that they are, with or without more detailed findings from Judge Hilton. First, below, although Mr. Bono says this is all about AdWords and keywords, this is what Mr. Wu Pang, in his declaration, admitted below, this is his client. With respect to paragraph 6, he says it constitutes, quote, social media restrictions that prevent Woody from using its GT Racing mark or the words GT Racing or GT space Racing in connection with certain goods in the European carve-out. That is Class 9, 20, and 28 goods. He also admitted that the social media advertising posts that Woody makes used those prohibited terms in connection with Classes 9, 20, and 28 goods and were accessible in the ECO. This is found at the Joint Appendix pages 222, paragraph 9, and 223 at paragraphs 14 to 15. Mr. Wu Peng also admitted that the customers in the ECO who accessed these social media posts to purchase Class 9 and 20 and 28 goods were simply redirected to other websites to complete those sales. They were making advertisements and sales in the ECO exactly contrary to the terms of paragraph 6B. Now let me talk about 6B for a moment, because Mr. Bono went through a litany of the contract terms governing content. And the one he left out was paragraph 6B. There are twin aims in that paragraph. The first clause of paragraph 6B clearly is addressed to AdWords and is phrased in prohibitory language that's very clear. It states that Woody will not buy AdWords from search engines. That clearly limits Woody from buying as meta tag AdWords using my client's trademarks or GT Racing. The second clause says that Woody will not use GT Racing on Facebook and other social media platforms. This is a limitation on content. This is the exact formulation used in every paragraph he just cited to you as pertaining to contents. That's paragraphs 2, 3, 4, 5, all use the same will not use on prohibitory language. Paragraph 6B, the second clause, which we were seeking to enforce, says that Woody will not use GT Racing on Facebook. We are clearly talking about content in that paragraph, that clause of that paragraph, just as we are in every other paragraph in the agreement. Mr. Bono also catastrophizes in his argument, saying that enforcing it the way it's written.
Counsel, I guess to be fair, your opponent draws attention to the use of the word terms, right? Will not use any terms that include GT Racing. So what's your argument on that?
I think he's trying to make a distinction without a difference. Again, this wasn't an argument that they made below at all. This came up for the first time in their briefing, that what they're saying is that it would make meaningless the word terms, but what's clearly agreed to in there is that they wouldn't use GT Racing in association with any, either in isolation or in conjunction with any other words. For example, GT Racing chairs, GT Racing mouse pads, GT Racing other products. So there was always this idea that, and the web pages that we've attached that are in the appendix show how they use GT Racing in all of these social media posts in association with other words, describing the user experience of using a GT Racing chair, things of that nature, all of which are being done to attract customers who are then redirected. So again, they are making these advertisements purposefully to attract purchasers, erode our goodwill, invade our territory, if you will, our protected territory, and then make sales, which they claim are outside. But the restriction, as we advocated and Judge Hilton found, was correct. And by the way, just on that finding, a finding even on affidavits or other evidence, even without live testimony, is still subject to a clearly erroneous standard under Rule 52A6. And I would submit that that's the lens through which his findings should be viewed. But Woody is not being required to shut down any of these social media platforms. This was accounted for in the agreement itself.
So you're wanting us to defer to findings that haven't been made.
I respectfully, I
And if
understand.
there's no record to support, I mean, you sound like you're the witness, and I guess you are. And we're not fact finder.
What I am reciting is all in the record in the affidavits. So
But they're
I hope.
conflicting. The affidavits don't agree with one another. You haven't stipulated that they're all true. They don't say they're all true. You don't say they're all true. Both sides. You all you agree that everything his affidavit said is true? Does he agree with everything your affidavit said is true?
No, they did not dispute.
We would have some facts, but somebody need to digest them a little bit, I suspect.
They did not dispute the facts that we presented in our affidavit. They made certain admissions about, and which I just went through, about social media restrictions and how they are using GT racing still in violation of that provision. The other evidence that they presented was about other methods they have been using to perform other provisions under the settlement agreement. But the key provisions of the settlement agreement and the evidence that we presented that was dispositive of this issue, interpreting and applying paragraph 6B, was not disputed by them. And they haven't identified any other evidence that they would have presented to the district court, even now, and certainly back then they didn't present any proffer of additional evidence that they would have presented. But even enforcement of it, as we've advocated, it does not require what, as I said, they catastrophized would be to shut down their social media platforms. This is accounted for in the agreement itself. It's limited goods, limited territory, but most importantly, and this provision wouldn't exist unless the provision means what we say it means, we were asked to pre-approve a dozen trademarks that they could use in Europe. These are listed in the Joint Appendix in Exhibit D, at Joint Appendix page 175. We pre-approved the trademarks that they could use on their social media advertising for all goods everywhere. That agreement, that pre-approval by us would not have been necessary if you interpreted the contract the way Mr. Bono is now for the first time to any court, arguing what it really means. This isn't the argument they made below, but it's certainly not supported in any way by the record. The record supports and is consistent with the interpretation that we have given all along, and that is that it's a limitation on content. I see my time is eroding away. I want to answer any other questions that the court may have, but a couple of things. First, again, neither party can advertise and sell what they want, where they want, using whatever trademark they want. That's the purpose of the concurrent use agreement. We conceded a lot of our rights in order to achieve this settlement with the other side. If you were to undo the protections that we secured through negotiation in paragraph 6B to protect my client's interest in sort of his home base, the European Union countries, the United Kingdom, which we are called the ECO or the European carve-out, it would completely undo the benefit of the bargain that he was making at that time. So, they argued that, they didn't argue below that it was ambiguous. They didn't proffer any parole evidence. When asking for an evidentiary hearing, they didn't identify a single other witness because, by the way, there is no other witness. They have one principal. We have one principal. We would have put on Mr. Wong. They would have put on Mr. Wu Peng. He would have testified exactly as he did in his affidavit. Mr. Wong would have testified exactly as he did in his affidavit. That point was raised before Judge Hilton at the first hearing, and they made no protest at the time. Again, Mr. Bono was not representing him at that time. It was a different counsel. But they made no protest at that time that they needed evidentiary hearing to present live testimony from any other witness or to present any other documents. Now, at the second hearing, when the same issue came up, Mr. Bono still didn't offer anything new. This was on the limited remand. So, again, and that was only for clarification, but so even here now on appeal, they haven't identified any other evidence they would present. I respectfully submit this is an order of specific performance. They've pointed to 3 indicia. They say, well, this proves it's an injunction, that it orders them to do a specific task by a specific time on penalty of contempt. But let's look at what an order of specific performance is. And we've cited this, it's in our brief, pages 28 to 30. Under Virginia law, the remedy for specific performance allows the court to compel a specific act in compliance with the party's contract, exactly what Judge Hilton said he was doing. It may incorporate terms and conditions by reference from the contract, exactly what Judge Hilton's order does. It may state a specific time for performance. He did that here because all the time for performance had already lapsed by many months by the time he entered the order, so he set short timetables. Again, when asked if they wanted to lengthen that time, if they want any other changes to the order, they said no. And it may be enforced by contempt. There is no other remedy, by the way. And we point out that under Rule 70, specific performance orders are looked at differently than injunctions under Rule 65. So the arguments they're making that sort of looks like a duck, quacks like a duck, walks like a duck, if that's a legal principle, it also looks just like a specific performance order. So you would look beyond what is being ordered. What is being ordered is exactly as Judge Hilton said, it is compliance with the party's contract. An injunction under Virginia law as a remedy would preserve or restore the status quo or prevent a future wrong. We requested an order of specific performance. That's what Judge Hilton entered. If the court has no other questions, I thank you for your consideration and ask you respectfully to affirm the judgment below.
Thank you, Mr. Riley. Mr. Bono, you have some
May
time
I
reserved.
respond, Your Honor?
Yes, sure. You have time reserved.
Thank you very much. With regard to Judge King's questions about conflicts in the affidavits, it's blatantly in conflicts. Mr. Peng's declaration at JA 222 directly disputes that Woody has an obligation to take down social media advertising in other countries merely because it's accessible in the ECO. He definitively disputes that, says he bargained for the right to do that. So you couldn't have a more defined conflict in the facts just on that alone. Secondly, I specifically asked at the second hearing in front of Judge Hilton for findings of fact and conclusions of law and evidentiary hearing under the Hensley case, even if it was viewed as a specific performance order only, which I respectfully submit it does not. Third, the order, if you read it, is an injunction, and it does because it pulls out terms that are not in the agreement. It says, for example, just in the first ordering paragraph, it says, Woody, take down all posts whenever made on its proprietary social media platforms that are accessible in the European carve-out. That phrase, which are accessible in the European carve-out, does not appear anywhere in the settlement agreement. That is something they want to engraft on the settlement agreement, not there, not bargained for, not agreed to. That is, in fact, just the opposite. Woody bargained for the right to advertise its branded products with its GT Racing trademark on social media sites everywhere in the world. The accessible notion that's in this ordering injunction is not in the agreement. This is clearly an injunction. He argues for its specific performance. So this tells enumerated steps. We have to do this, we have to do this, we have to do this, we have to do this. Not in the agreement. We have to do it by a certain date or we're going to be held in contempt. It is an injunction, and it clearly meets the cases which I think were cited in one of this court's preliminary orders. The 10th Circuit case says you don't have to use a magic word. And whether Judge Hilton thinks that's an injunction or not, with all due respect to Judge Hilton, is not really the defining point, because when you look at that order, it is an injunction, or at least it's an injunction, has an injunctive nature order. And in addition to not making findings of fact, conclusions of law, or allowing argument or testimony as to the conflicting affidavits, he never analyzed the eBay factors for entering this injunction. He never made any findings with regard to irreparable harm.
I have a question about that.
Sure.
It seemed odd to me, but maybe it's not. Maybe you can explain why should a party have to show irreparable harm for their contract to be enforced? So this was a proceeding where you had, you all reached this settlement agreement as part of this litigation, and then there was a window of time to come into compliance with it. And it wasn't apparent to me why one party would have to show irreparable harm to force the other party to come into compliance with the agreement.
To satisfy the requirements for an injunction, if they sued and said, we breached, the normal proceeding is that they could establish the breach and they could prove monetary damages if there was a breach and if they sustained damages. That's the normal course. An injunction is an extraordinary remedy, even in a breach of contract
But the
situation.
context here is a little different, right? Because the whole point of this window after the settlement agreement was reached was to allow the parties time to come into compliance with the agreement. And then the day after that lapsed, while the case is still open, they say, hey, look, they're not in compliance yet. Please order them to comply.
And that, if it had simply just been compliance with the terms as they were negotiated, Your Honor, perhaps, but the order went well beyond that. It went beyond the agreement.
So you think is your answer saying if I agree with Judge Hilton that that's what the agreement requires, I agree with his interpretation, then it's not an injunction? But if I disagree with his interpretation, if I think that he's going beyond what the settlement agreement said, then it is an injunction?
No, I think that's an added element, an added factor, Your Honor. It's not preclusive of whether it's an injunction or not. I'm just pointing out that even beyond the order as written is an injunction, I respectfully submit. And I believe because of that, and because now it's turned into a permanent injunction with the final judgment, and that was the only order we agreed to that my counsel misspoke, the form of that injunction, the form of that judgment, because it was attached to the settlement agreement. We never agreed with this April 29 order of Judge Hilton. Never, 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 never. I would like to make one point if I could, because in looking at 6B, and I was sort of surprised when he said, well, I never mentioned 6B, because that's the centerpiece of this dispute. This whole dispute is you have this massive settlement agreement. There's only allegation of a violation by my client is this one phrase buried in a subpart of this paragraph 6B. And he doesn't, and he only takes issue with the second phrase, which is, will not use on Facebook or any other social media platform any terms, as Your Honor pointed out, that include with or without other words. Now, I respectfully submit that if they wanted to bargain for a prohibition of my client posting on a social media platform its trademark, that would not have been written that way. You would say,
It's a little confusing, right? Because there are the other paragraphs you mentioned, like paragraph 2, uses explicit language about metadata. It refers to metadata. It refers to using it visibly or in programming or code. You know, the argument you're making about visibly and invisibly is a clever one, but the agreement suggests that if that's what they meant, they'd use those words because they're used elsewhere.
Well, I'm not sure about your adjective clever, because I don't know how you're using it.
I'm sorry, I mean it complimentary.
Oh, all right. Then I'll take it.
But it has some appeal, right? When you understand how these sites work. But then I start to doubt that when I see that elsewhere in the agreement it specifically calls out visible and invisible.
Well, the point is, the parties knew this difference. And the parties knew how to say, if they wanted to say something visibly on or content appearing on, they knew how to say it, and they said it in this very agreement. Paragraph 6B doesn't say it. And he uses the word on, which if one looks at the Merriam-Webster's dictionary for the word on and its use as a preposition, you'll get a list of about 25 definitions. It is a very varied word, I respectfully submit. One of the definitions of on is respect to, with respect to. That is the context of this word taken in our English language. Will not use on Facebook. Terms. It's simply saying you won't use the terms on the Facebook platform, but terms is not visible. It's not talking about putting these words on, on the pages that a user would see. It's talking about the directed advertising, the AdWord function, which is in the first phrase of this sentence. And I will say, look, what they're asking for is you to interpret the first phrase one way and the second phrase the other way. They never argue that using AdWords on Google is something that is visibly on the content of anywhere. It's not. And you would phrase it this way. If they were to ask my client on the witness stand, how would they ask him whether Woody is using AdWords? The question would be, are you using AdWords on Google? That would be the English question. That's not saying you're using AdWords on the visible content of Google or the shopping sites, Amazon or anything. It's the predetermined directed advertising program that these websites have. The word on here is not something that connotes visibly on. They knew how to say that in this agreement, and they said it, and they didn't use it here. And this is strictly in the context of with respect to. So what they're saying is, and the phrase, I would say this, when you look at 6B, and this is very important, the phrase, any terms that include with or without any other words, any of the following GT Racing, that phrase is applicable to both the AdWord phrase and the use phrase of Facebook. Because when it says will not buy AdWords from Google, that's not a total preparation. It's saying will not buy AdWords from Google it should say contain any terms that include. That last phrase applies to both Google AdWords and using on Facebook their terms. So it's an equal use of that phrase, and they don't contend Google AdWords or the like. I mean, you have on Amazon, there's Amazon ads, there's on the other shopping sites, Newegg. We pointed this out. They have their own phrase. AdWords is Google word. Others use different words. But it's talking about the non-visible directed advertising programs that these platforms have. And if they wanted to negotiate this settlement and have my client agree that they would not use their branded share in an advertisement anywhere in the world, even though they specifically bargained for the right to do that, and they paid $4.5 million for the right to do that, that somehow they wanted to say, no, you can't do that. You can't do that in the United States. You can't do that because somebody in the UK might see it. That it would not have been buried in paragraph 6B. It would not have been phrased this way. This is not what this means. It's very clear it doesn't mean this. They're overreaching.
Let me get you out of the weeds a minute. Your time's way up.
I'm sorry. I apologize.
Chief Judge Gregory has been very gracious to you. What do you want us to do with this case? Your two appeals?
Your Honor,
Be succinct.
Well, Your Honor, I believe at the very least you should reverse this order and remand for further proceedings, findings of fact, and conclusions of law in an evidentiary hearing, because I believe that has to be done in the context of this order. And if you do that, I respectfully submit that you continue the stay in effect until that is done and we can see what Judge Hilton does, so my client is not prejudiced by the additional time on this. And if you're unwilling to accept my argument at face value on what the agreement says based on this record, which I think you can do if you wanted to, but I think at the very least you would need to remand on this record as I've indicated. Thank you very much. I appreciate the gracious time allotment you provided to me. Thank you very much.
Thank you, Mr. Bono, and thank you, Mr. Riley, as well. Appreciate your arguments. And again, we suspended our tradition of coming down to greet you under the circumstances, but know that we appreciate your arguments and your being here. So we wish you well, and we'll ask the clerk to adjourn the court for today.